Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Bill Scarborough,
Here.
Joe Sucher,
Here.
Belinda Billings here, Brian Galley,
Here.
Jason Borshon,
Here.
Ron Ritchie, Tom Patel.
Here. Next item is the agenda. Do we have any changes or additions or deletions? I would entertain a motion.
Motion to accept the agenda as presented.
I'll support. Tompkins.
Support.
All in favor, say aye. Aye.
Aye.
Opposed? Motion carries. Public items, public comment for items not on the agenda. We have no audience. Do we have anybody online?
No.
Okay. We've got 3 people in the audience. Do you guys want to say anything?
Well, we'll have plenty to say.
Okay, so we'll move on from that public hearing. We have no public hearings, regular business. Item 1. Planning and zoning training workshop. Take it away, Mr. Carlisle.
Okay. Are you gonna pull it up here? Okay, great. Well, this is gonna be a tag team match tonight with Morgan and I. I'm gonna do the first part, and some of the stuff you will have probably seen in your basic planning courses that you've taken, but we're gonna, I'm gonna expand on some of it. Morgan is going to, on the second part, the first part is going to be planning and zoning principles. The second part will be running successful meetings. And that's where we're going to get into more legal aspects that Morgan's going to cover.
There we go. Hopefully that'll work.
This is the agenda. So we're going to talk about roles and responsibilities, planning and zoning principles, and then I think a little bit more extensive discussion about running the public meetings, public comment rules, passing and amending motions, the Open Meetings Act, ex parte contact, and what, we're going to talk a little bit about closed sessions, although that happens infrequently with the planning commission, but occasionally it does. So go on, Brian.
Technical difficulty.
Yeah, apparently. Well, we have the presentation. Okay. Let's move on, Brian. So,
There we go.
okay. One of the things I want to impose on you is that we have a system here and everywhere where planning and zoning decisions are not made in a vacuum. The planning commission is obviously a very, very important part of that. But you also have a township board and a board of appeals. And you also have administrative and support staff that have a role to play when it comes to your decision-making, when it comes to land use decisions. When I talk about land use, we'll get into more detail. But site plans, special land uses, rezonings, PUDs, the whole 9 yards. And so it's essentially a system that's been set up where each board, each body has their roles and responsibilities. You know what I'm saying? So essentially, it's local government is set up very much like I hate to say this, like the federal government, where you have the legislative body, you have the planning commission, which is essentially the administrative body, and then you have the semi-judicial body, which is the zoning board of appeals. So we have this separation of powers when it comes to zoning, administering the zoning ordinance and making zoning decisions. So we call it checks and balances. So you are an appointed body. Obviously, the legislative body is an elected body. They make appointments to things like the PC, the DDA, the CIA, the ZBA, things of that nature. They are the ones that eventually can adopt or amend the master plan, and we'll talk about that in the second part of our session tonight. They're the ones that actually do the formal adoption or amendment of the zoning and other ordinances. They approve subdivisions, which we don't see hardly anymore. They adopt the budget, your budget. They adopt the CIP. There are certain processes where they may get involved in development, reviewing development proposals. Predominantly, you'll find it's here, it's just PUDs. And they are the ones that hire staff. You are the body that develops and recommends the master plan, which we're going to talk about in the second hour tonight. You're the ones that develop and recommend zoning ordinances, the zoning ordinance and amendments thereof to that zoning ordinance. You do review and approval of special land uses, site plans and PUDs. You have exclusive approval of our special land uses and site plans. PUDs, you're a recommending body. Technically, the law says that you are to develop a capital improvements plan. That's something that we would essentially, the law requires the planning commission to develop a CIP, but the problem with the provisions in the law is that you're not the body that has any provisions to spend the money as a township board function. So typically, how we really address that is the recommendations that come out of the master plan really fit into the township's capital improvements plan. But technically, you could have more involvement in the capital improvements plan in this township. This township has not done it. They've had a capital budget. And frankly, very few communities have their planning commission do a capital improvements plan. If we had subdivisions, you'd be recommending those. And technically, we're supposed to be providing an annual report. Usually, that's really found in the minutes of the planning commission, but you could actually do a final, technical annual report every year. For those of you that have sat on the Board of Appeals, Mr. Galley for one, I know Bill has been the alternate. The Zoning Board of Appeals is an appellate body. They're the ones that interpret zoning ordinance, texts and maps. Generally, that's when that is either sent to them by the zoning administrator or when there is an appeal of a zoning action that is typically an administrative appeal that will go to the zoning board of appeals. So for example, let's say Brian makes an interpretation of the zoning ordinance and an individual disagrees with that, that decision can be appealed to the zoning board of appeals for administrative, for interpretation. The zoning board of appeals obviously takes action on variance requests, and as I said, they are a quasi-judicial body, and their decisions are final. Their decisions cannot be appealed internally. The only recourse is for appeal is for court action.
Can you do it from the podium, because you can't hear you? Okay.
Unfortunately, now I can't see it, but that's okay. No, it's fine. We don't operate, in another way that you don't operate in a vacuum is that you are a creation of state law, okay? The Planning Act is Public Act 33 of 2008. That act was a complete consolidation of what was 3 different disparate acts dealing with cities and villages, townships, and counties that dealt with planning for all 3 entities. In 2008, those were all consolidated in a single statute, which is, in my opinion, very well and logically written. The Zoning Enabling Act, same thing. We had the Zoning Enabling Act had 3 separate statutes. By the way, the Municipal Zoning Act, which dealt with cities and villages, was passed in 1921 and amended numerous times. The Township Rural Zoning Enabling Act was passed in 1943. And so what you had here in both the Planning Act and the Zoning Act was different procedures for both townships, cities, and villages. And it turned out to be very confusing, especially for people that, especially for people that represented all different entities, and also for applicants who may be operating businesses or developing in various communities. So they had, and both, many of the acts had different public hearing requirements, and the consolidation into a single Planning Act and single Zoning Act has been extremely beneficial to increase the understanding of what procedures are that are universally now across the state. Go ahead. We also operate under other legal constraints. I mean, you have to operate under the zoning statute. Our zoning ordinance is adopted in accordance with the Zoning Enabling Act. The master plan will be adopted in accordance with the Planning Enabling Act. You are established in accordance with the Planning Enabling Act. But we have other laws that we have to be cognizant of. There are federal laws, there are state laws. As Morgan knows, there's case law that dictate what we do that cause us to have to modify our actions. There are attorney general opinions that we have to abide by. And there are other local ordinances that we have to be cognizant of. You, for example, as our planning commission, also serve as our wetlands board. And that came about, we used to have a separate wetlands board, but it came about when the wetlands law was modified to say that you couldn't put people through two different processes. And that's why most communities that require a site plan review through a planning commission and a wetlands permit used to require it through a wetlands board, consolidated all that responsibility with the planning commission. So you are also the wetlands board, and you have, we don't see tremendously number of them because generally we've been fortunate in not having people impact wetlands, but occasionally we do, and you're the body that makes that decision. In your zoning ordinance, and from time to time, you'll see this in my reviews, you have both non-discretionary and discretionary standards. And non-discretionary standards are fairly cut and dry. It's so many parking spaces. It's this setback. It's that lot size. It's this height of the building. So those are generally non-discretionary. So in other words, if somebody meets that requirement, they have met that requirement, and you have very little discretion to modify that. So if they meet the building height, they've met that ordinance requirement. However, throughout the ordinance, you have many circumstances where there are discretionary standards. Even in your site plan review provision, while we're applying non-discretionary standards to some degree with site plan review, there's a lot of discretionary standards over which you have to exercise your judgment. Traffic effects, internal traffic circulation, buffering from the neighboring property. There's a variety of things over which you have discretion in terms of making a decision. You also have entire processes that are discretionary, such as the whole special land use process is a discretionary determination on your part that land use that is only allowed on a case-by-case basis in various districts meets the standards of your ordinance to ensure that it is compatible, harmonious, doesn't create an undue burden on surrounding property owners or on public services. So there are a variety of standards in your judgment that you have to make that determination. So those are discretionary standards. And surprisingly, you do have more discretion over decisions sometimes than you may think that you have. And if you ever have a question about it, that's what we're here for, Brian and I, your township engineer, to answer those questions for you. Can we vary from that standard? Sometimes I'll say no, because it is a clear-cut standard in the ordinance. But where it's a matter of judgment, this is why you, as planning commissioners, are voted as, appointed as representatives of the community to reflect what you think is in the best interest of the community. Now, that's all well and good, provided, and as Morgan will tell you, you don't apply those standards arbitrarily. And so as long as you are applying a standard that is discretionary, that protects public health, safety, and welfare, and two, advances legitimate governmental interest, you're going to be on pretty safe ground. So essentially, that's the difference in your role when you're in a decision-making role in terms of exercise of discretion versus non-discretion when it comes to application of standards. So if you read through the site plan review section, and you'll see this whole list of standards for approval, those are all, when you're reviewing a site plan, it's all in your judgment, based on the advice that you're getting, based on your reading of the plan that's before you, based on your understanding of the ordinance, based on your knowledge of the area. It's within your judgment as to whether those standards are met. It's the same thing with special land uses or PUDs. Again, that discretion has to be carefully exercised to avoid, an arbitrary decision, but it is within your discretion to make that. So, when it comes to the planning approvals, from special land uses, you have exclusive approval. It does not go to the township board. Some communities it does. The Enabling Act gives the community the ability to decide in their ordinance who makes the final decision. In some the law actually even allows for that to be done administratively. Frankly, I don't see that very often, and I don't recommend it. But the law allows that to occur. But essentially, in most places, it's a planning commission decision, sometimes a legislative body decision too. Same thing with site plans. You have the sole authority over approval of site plans. When it comes to rezoning of land, you make a recommendation, the board decides. It goes on to the township board. The same thing with planned unit developments. A PUD, which is essentially in this community an act of rezoning. You make a recommendation, it is the township board that decides. And finally, in the case of variance, it's the zoning board of appeals that makes that decision. Now, just one, from a procedural standpoint, something that you should be aware of is when you are reviewing a site plan and it requires a variance, our ordinance requires that you first review that site plan for conceptual site plan approval, then it goes to the Board of Appeals. And so your decision on a site plan is not final. It goes to the Board of Appeals. The Board of Appeals makes the decision about the variance, and then it comes back to you for final site plan approval. We do it that way for a very good reason. We do it that way because if we would send variances to the Board of Appeals prior to go to the Planning Commission, a couple things would happen. One, it might tie the hands of the Planning Commission in reviewing that site plan. But frequently what we see happen is that when the Planning Commission ends up reviewing the site plan, even in a conceptual level, sometimes we come up with solutions that make the variance unnecessary. And so that's why we always make this more of a planning-driven process and put the Board of Appeals in the middle. So it's just as a general rule, your decisions should always be supported by evidence. Experts can provide you with an invaluable service, and I'm not just talking about what we provide. You obviously have municipal attorneys that represent you. You also have an excellent engineering firm, and so collectively, it's our job to provide you with the information that you need to make a decision. And if we ever not do that when it comes to a particular issue and you need more information, it's well within your right to have the matter postponed until you get the information you need. There are other experts also. I mean, occasionally we rely upon information from the Road Commission or from NDOT or from the Health Department, who in their areas exhibit expertise over that particular subject matter. So again, it's always better to postpone a decision if you feel you have incomplete information than it is to make a decision based, a decision that you're not sure the information is complete. So it's always a good idea to get the information that you need. But your decision making is not, again, from a legal standpoint, the Kelly firm will tell you this, you don't have absolute control over the right to control land. It has to be within the constitutional rights of the individual involved. It also has to be, the rights of the public have to be weighed against the rights of the individual. People do have the right to use their land in a reasonable manner. Your job is to determine what is reasonable and what is not reasonable. And it has to be able to be defended. And so your decisions should, have to be done in a fair manner, in a reasonable manner, and that means not arbitrary. Now, does that mean that you have to guarantee someone is able to make maximum use of their property? No. What it means is you have to allow everyone to make reasonable use of their property. And reasonable is a legal term, but in the judgment of our legislature, they created planning commissions to come up with those reasonable decisions because you are knowledgeable, objective members of the committee. And so that is why it's a tough job. That's why it's a difficult job, but that's why you're put in this position, is to make those decisions. But again, decisions made in the absence of good information, subject you to being challenged, and to the township from being challenged, not only from the applicants, but from citizens, and ultimately undermine your decision-making capability. So always a good idea to rely upon information that helps you make that decision. So we'll talk about this later, but the master plan is really what provides us with a defense in zoning litigation. I've done hundreds, probably a couple hundred cases as an expert witness, and I always feel a lot more comfortable when I go into a case knowing that that community has their master plan is well thought out, it's up to date, they've kept it up to date, it's not 25 years old. And their decision was based reasonably based on their master plan. And obviously zoning can't exclude otherwise lawful land uses, but sometimes there are exceptions. And there are times when that occurs, and we will certainly be here to point those out to you. So I think that concludes this part of the presentation. Oh, finally, we always follow procedures. Due process requires that you follow procedures, and you do it equally. You treat applicants in a uniform manner by requiring uniform procedures. And it's always best to deal with issues in a prompt manner. In other words, don't arbitrarily delay something just because you're not ready to make a decision. However, it is not, where there is arguable facts that need to be researched or information you need, you're not required to make an expeditious decision just for the sake of making that decision. So I think that is my last slide. Yeah. Oh, here we go. Open meetings and express an opinion. Zoning decisions are made in open meetings, and Morgan will get into that. And it's regarding, commissioners should avoid expressing an opinion regarding a decision until all the facts are there. Always ask as many questions as you feel necessary to get the information you need. Okay, and that's it. Well, if you want, we can hold questions till the end, or I can take questions now, or we can go on with Morgan at this point.
I had a question. You're talking about some of the zoning principles. Isn't unlawful taking one of the most common arguments?
Yes.
Can you explain that to the people? Or Morgan?
I was
whoever.
going to go into it, so
You
that's
were? Okay.
perfect. Yep,
We can wait till then.
Yeah.
perfect.
A question on the statutory stuff, and this is
Mhm.
kind of a comment. I had an uncle who was a mayor of Chesaning for
Right.
20 years, and he was still mayor when I got on these commissions, and he's like, what kind of township are you? Charter township? And I said, yeah, it's Charter Township Independence. He goes, oh, because that gives you more protection. I mean, is that true or not? Is there different ways townships were founded?
Yeah, I mean, there's general law and there's charter townships. Morgan might want to comment more on that, but generally the Charter Township Act, one, allows the township to levy additional millage than a general law township. And second of all, you have greater protection against annexation.
Okay. Yeah, and I didn't know if that had changed with the updates to the planning
No.
acts and such,
No,
if it was
that,
old law.
yeah,
and it got
separate.
worked out. Okay.
separate statute, so.
I have a question. So in your handout, you said the planning commission developed and recommends zoning ordinance amendments. So I have a personal situation I want to ask you about. I live in the subdivision that abuts Sashabaw Corridor. Brian is familiar with what I'm going to say. We have 30, our subdivision is 30 years old. We have a
Mhm.
pond that's never been dredged.
I'm sorry,
A pond that's never been dredged.
right,
So in our ordinances, I read about maintenance of ponds, but no schedule is,
it's
it's a natural pond
okay,
that was turned into a retention pond when our subdivision was built. So this also kind of goes along with the wetlands because we are in a wetland area, but not a protected wetland. So I've had the state out to look at it, do a site visit. They walked the pond with me. They said, yes, it needs to be dredged. And I submitted the paperwork for a permit. It was granted, but our HOA won't dredge the pond. And I know Brian said y'all don't get involved in HOAs, but shouldn't zoning regulations for our township supersede HOA regulations?
no.
Yeah.
Unfortunately, because it's property owned by the HOA, it's not dedicated to the township. The township has no authority to force the HOA to dredge their property.
Okay, what happens when it becomes a public safety issue? Because our road that goes along beside the pond has already eroded, and the road commission came out last year and pushed down a big section of all the trees and stuff down to the bottom of the pond and repaired the road. And what happens when it becomes a flooding issue? Because the pipe that goes into the protected wetlands has never been cleaned in 30 years. So how can you separate yourself, you know, as a township to say, we don't have any authority? It's almost like they have their own little world if
There
they're
are
not.
probably policies in your master deed and your HOA bylaws that would allow you to petition the HOA, basically to force them to do it. That's a whole separate issue. I can discuss it with you later if you
I
want
would
to.
really appreciate
Yeah,
it.
absolutely. That's not a
Okay.
problem.
Thank you.
All right, are you guys ready for me?
Yep.
Good evening, everyone. You want to go on to the first slide, Brian? Thank you. So the first question is, normally we're very strict about procedure. I know you guys know that. The question is why? And the reason for that is that we want to make meetings as efficient as possible. I think everyone agrees with that. Not only do you guys want to get out of here in a timely manner, but you also want to avoid any sort of legal action based on your decisions. So when we follow things like the Open Meetings Act, our bylaws, our ordinances of the township, and Robert's Rules of Order, that really limits our likelihood of getting sued in the future. And even if the township were to be sued for any sort of incident that happened at a planning commission or any decision by the planning commission, if we follow the proper procedure, it limits any potential liability that may come in the future. That's why this is so important. So this is some very, very basic tips for a successful public meeting. The first one is the chair, Bill. You are in control of the flow of the meeting. You announce all business, you recognize all members. If there is some sort of commotion going on, you're the one that's supposed to call things to order. You make sure that the procedures are being followed. If two people are arguing, you recognize the member that has the floor. If someone is behaving inappropriately in the meeting, you're the one that's supposed to call that out. That being said, that's not solely your responsibility. It's primarily your responsibility, but other board members, other commissioners can get involved as well. If something is happening that's inappropriate or violating our bylaws and Robert's Rules of Order, any single person on the commission has the authority and the ability and should call those things out. The most important thing always is the bylaws. So the bylaws govern how our meetings are supposed to flow. The bylaws say things like the typical order of an agenda, how long public comment should be, if we follow Robert's Rules of Order, which we do, and any specific thing that needs to be addressed is either going to be, any rules that need to be made are either going to be in the bylaws or they're going to be in Robert's Rules. So when in doubt, follow both of those things. If you have any questions, look at the bylaws first. If it doesn't address it, then go to Robert's Rules. That will address it. I don't know, I'm sure you guys are all very familiar with Robert's Rules, but it's a book about this thick that says every possible thing that you could possibly question about an open meeting. So if you want to know how a motion should be phrased or what happens in the event of XYZ, it's almost certainly going to be in there. And ultimately, we're familiar with those things, so you can always ask me or whoever is at the meeting. Or if it happens during the course of a meeting, one of our attorneys isn't there and you have a question later, reach out to us. We're happy to help. And ultimately, things like an incorrect procedure, while they're not ideal and they should be avoided, that's not going to invalidate a decision of this commission. So do the best you can, but don't stress about it. If you move to amend something and then fail to vote on that motion to amend and vote on the original motion, you mess something up in the order, it might cause confusion, but that confusion then will be just interpreted by the court. It's based on the intention of the commission and not necessarily exactly how you got to that point. Ideally, you guys are going to follow every single rule, but no one's perfect. That's simply not going to happen. So just do your best. The most important thing is maintaining control of a meeting. I think you guys are pretty fortunate in that we live in a very, reputable place. People aren't fighting. We don't have to call the cops. I've seen that happen before. So you have less worries about control, but it really is important. You don't want people speaking when they're not supposed to be speaking. You don't want to, really the biggest deal is you don't want to cause confusion for the future. If a court were to have to come back and interpret what happened during the meeting, you want it to be as clear as possible. And it's very, very hard for things to be clear when people are speaking over one another. So avoid that if all possible. Second, and really the most important thing is making sure motions are clear. So even if the rest of deliberation, even if the rest of discussion gets a little hectic, the motions themselves should be clear. The easiest way to do that is to have, and I know you guys do this, to have proposed motions. Those can be read into the record and then seconded. Then deliberation happens, and then before any vote is taken on the motion is repeated. That way everyone knows what they're voting on, everyone's clear on what is before them, and it really makes the minutes a lot easier. Obviously, the minutes don't say every single thing that happens in every single meeting, but they do record the important things, the action that's taken, and that's the minutes. So when our administration is going through and preparing those meeting minutes, it's very helpful for them when the motions are repeated later. Again, talking over one another, please avoid it if at all possible. It's just like in a courtroom, it's really difficult to figure out what's going on when people are talking back and forth. My recommendation is to always wait till someone's finished talking before you start talking. If you have any questions about whether they're done, you can ask if they cede the faire or direct your questions to the chair, and then the chair can make sure that the order is being followed. After a public comment or a public hearing, you can answer any questions that were asked during that public comment or a public hearing. But during that public comment and public hearing, don't go back and forth with a resident or anyone who's speaking. I suppose they don't always have to be residents. That, again, causes chaos, and it also is just inappropriate because you can give individuals the appearance that there is preferential treatment going on. For example, if one resident poses a question or makes an argument or suggests something for consideration and a member of the commission immediately responds back, but the next person comes up, they make an argument and no one communicates back and forth with them, either one can feel as though they were slighted because there was back and forth between the commission and that person, and not the same for the next person. It's always better to, if you feel like you need to answer a question later, write it down and then answer it at the conclusion of public comment or public hearing. If, and I've seen this a lot, if a member of the public is asking a question and they're really pushing to get an answer immediately, the chair can address and say, we will answer all questions at the conclusion of public comment. That is the sole statement from the commission that should happen during public comment or public hearing. Again, this slide is a very general summary of what should happen during a public meeting. In fact, all of our slides are directed towards any board or commission, so I'm going to add a couple of things that are very specific to the Planning Commission. The first is something that Dick talked about, and that is that sometimes the Planning Commission has discretion. You can make decisions, and you're not required to, sorry, Brian, I'm not quite there yet. I apologize. Sometimes there are questions that will come before you that the answer is not obvious from the zoning ordinance. And that gives you guys discretion to determine what you want to do with that. When that is the case, the most important thing that you can do is make sure that your decision is not arbitrary. And arbitrary just means that it's without basis in fact or law. If you have any question about whether or not a decision is arbitrary, always refer your decision back to some sort of concrete basis. Things like the zoning ordinance, things like consultant reports. So I am not granting this SLU because in his report, Dick said these things were concerns of his, and the zoning ordinance requires that we consider these things, so I don't feel comfortable granting this SLU. Also, the master plan, as Dick very clearly stated, especially when it comes to rezonings, you have to consider the master plan. It's always better when you're making a decision to base that decision on one of those things. Some sort of, I mean, it can be anything really, but it's make it clear what you're talking about. Stuff like the zoning ordinance, the Planning Enabling Act, the Zoning Enabling Act, any of the consultant reports, an expert opinion, those are very proper things to base a decision on. And I know your zoning ordinance generally has considerations for approval. So naming one of those considerations gives you an out. Then the judge will say, nope, this is based on clear evidence. So there was a reason for this either approval or denial, and so I don't find it to be arbitrary. The second thing in making sure that a decision is not arbitrary is consistency. So make sure that you treat every single person that comes in front of you, every applicant that comes in front of you, the same. If you grant this site plan approval for a car wash and it has X, Y, and Z features, and another car wash comes before you a year later with those exact same X, Y, and Z features, you must either grant or deny both of them. If you grant one and deny the other, it gives the appearance of impropriety. You might have a legitimate reason, right? But when you're failing to maintain consistency, that gives the appearance that the decision was arbitrary. The next thing is that something Dick also talked about, and that is that property owners have constitutional rights. Their rights aren't just based in state statutes, they're not based in ordinances, they are based on the US Constitution. And as a result, we have to balance those rights with the rights of the township to zone properties and make sure that the township itself is functional, we'll say, which is the defense for zoning. And one of those challenges that usually comes about when a property owner says you are infringing on my constitutional rights is what's called a reverse condemnation suit. And that's what you were talking about earlier, Bill. A reverse condemnation suit is essentially an argument by a property owner that the township has interfered with the property owner's use and ability to enjoy the property. Basically, they've reduced the value of the property to 0 for the property owner because of their interference with it. This typically occurs when there's some sort of, I'll give you an example. And this is not true for you guys' zoning ordinance, but in some of our municipalities, we have a parking zoning district where the only thing that the property can be used for is parking. If there is no longer a need for parking in that location and the city refuses to rezone the property in a request that's consistent with the master plan, that may then be subject to a reverse condemnation suit because that property has no value. You can't use it for anything other than parking. There's no reason that anybody's gonna park there, so it has 0 value to the owner. We want to avoid that at all costs. I will say, reverse condemnation suits are pretty difficult to succeed on because the property itself has to have 0 value. It can't be that, or effectively 0 value, I should say. It can't be that I bought this property that was zoned agricultural with the intention to build a house, and you now won't let me build a house there. You knew when you purchased it that you weren't legally entitled to build a house at that time. You chose to purchase it anyways, and now it doesn't have the use that you want it to, but it still does have some use. That would be a defense to a reverse condemnation suit. The last thing I want to say about this slide is, again, just bouncing off of something that Dick said. He specifically recommended that none of the commissioners give an opinion on a subject or an application before you guys until all consultant opinions are given, the administration gives their opinion, the application or the applicant speaks, and public hearing is concluded. Because if you give an opinion before the conclusion of the entire presentation, that gives the appearance that you've already made a decision, which suggests to individuals, may not be true, but suggests to residents and anyone watching that you may have made this decision outside the course of an open meeting. And as we're about to discuss, any deliberations towards a decision must occur in an open meeting. It gives the appearance of impropriety, which, if you take anything from this presentation, we want to avoid the appearance of impropriety. All right, I can give an additional summary of those kinds of things because I didn't give you that in my slides, and that was a lot of information, so I apologize for that. I will send everyone an email at the conclusion of this with some additional tips that are specific to Planning Commission. All right, now I'm ready, Brian, I'm sorry. So, as Dick discussed earlier, one of the things that we need to consider as far as legal opinions with regard to Planning Commission is the Attorney General. The Attorney General issues a bunch of different legal opinions, but one of their specific and most important opinions for you guys is that while you guys can create some rules for public comment, you can't put limitations on public comment that are so severe that it eliminates people's ability to speak. So you can request or require that each public comment is limited to, say, 3 minutes each. You're allowed to do that. And the reason for that, and it's actually beneficial, is that we want every single person to get the same opportunity to speak. So when we're limiting something to 3 minutes or 2 minutes, whatever we decide, that ensures that every single person is given the same opportunity. We want to avoid the appearance of impropriety. If we let someone talk for 10 minutes and then let someone talk for 2 minutes, that's not fair, right? So we're trying to avoid that. We also are allowed to require that anyone who steps up to speak for public comment identify themselves, so name and address. We are not allowed to limit anything else they say. If they start talking about something that's in closed session or illegal complaints against the city, anything that we might balk at, they're allowed to do that, and you're not allowed to stop them. The only thing that you can do is reduce the amount of time that they can speak for. So if they're allowed 3 minutes, you can shut them off right at 3 minutes. You're also allowed to limit when they can speak, so at a certain time during the agenda and not let it happen any other time. But otherwise, you shouldn't interrupt people when they're speaking. You shouldn't stop them from saying anything. And frankly, just as a tip in my experience, the more people react to a public comment, the more it gives an appearance that it is meaningful to the township. So if you try to stop someone from speaking, it almost makes it clear to everyone else that that is maybe something bad or something that we should be concerned about. If you just let them speak, generally people aren't alerted to the fact that it's something that they may be concerned about. Go ahead, Brian. Thank you. So we discussed some of this. You can't limit the subject or the issues that they want to talk about. You can't limit them from talking about confidential opinions. You can't, while I said you can require someone to identify themselves to speak, you are not allowed to require them to sign in or identify themselves in order to attend the meeting, only if they're speaking. And then finally, you're not allowed to require them to exhaust administrative procedures. So for example, in a court of law, if someone wants to bring an action against the township for the failure to grant a variance or something like that, or the failure to grant a planning commission, like a site plan approval, they have to exhaust their administrative procedures before they take that to court. That's not the case here. All right, next, Brian. All right. As you guys, yes, go ahead.
Can I ask a couple questions?
Yeah.
On I can't tell them they can't talk about something. But if it's a public hearing on a specific issue and somebody during that public hearing wants to talk about a different project, I can deny that, right?
Yes, and I was just about to get to that, so that's a
Yeah, I'm
perfect
jumping ahead.
timing.
And I've seen it happen before where somebody's time is up and somebody else stands up and he says, I'll assign my time to so-and-so.
No,
Don't allow that.
we do not allow that. No.
And
Go ahead.
in watching old planning commission meetings, generally we did not put a time limit on people. We just asked them to be brief. So if we follow that practice and then we have a big meeting and there's a lot of people here, and can I say at that meeting, we want to limit you to 3 minutes?
As long as it's consistent, I prefer.
Well, that's my question,
Yeah.
because in the past, we haven't limited it.
I mean, as long as it's consistent for every speaker. So you
Okay.
can say, at the outset of this meeting, for this meeting, we are limiting public comment to X amount of minutes, and then it'll be the same for every person. You can't let 3 people talk and then decide they've been talking for too long and then decide to limit it after. If that makes sense.
Is there a timer somewhere? I mean, how,
I don't think we have one in here.
Just use their phone.
Yeah.
it'd be nice if there was one.
Mm-hmm.
And it sounds like it'd be difficult if we generally don't put a time limit, but somebody's up there and goes on and on and on and on. Is it difficult for me then at some point to say, your time's up?
You,
Or like
you
get to
can,
the point,
yes,
you know.
you can call order to the meeting. So if someone is saying the same thing over and over and over again, you can say, calling this meeting to order, you have X number of minutes to finish because they're saying the same thing. And you can issue a warning.
Okay.
Is that you, Dick, or me? Okay. My apologies, everyone.
Sorry, I thought it was like the same ring as my phone.
I know.
thought I turned it
It's
off.
my work phone, so I don't ever turn that one off. All right, any more questions? Okay. So, like I said, what we were talking about before was primarily public comment. There is a difference between public comment and public hearing. So, and it's very interesting because some people, some municipalities that I work with have a public comment for agenda items and then a public comment for all other items. And when that happens, if you separate it by agenda items versus non-agenda items, then you are allowed to enforce that public comment for agenda items address only agenda items, and public comment not for agenda items be exclusive to everything that's not on the agenda. That is allowed. That's the only type of monitoring of subject matter that you guys can do. Public comment is generally less formal. It doesn't really have as many rules. Like I said, people are allowed to talk about whatever they want except for those two differentiations that I talked about earlier. Whereas public hearing is solely on the application that is before the Planning Commission. If someone starts talking about something that is completely far field, completely different, yes, as chair, you can and should interrupt them and inform them that they would have the opportunity to speak at public comment, but now is the time for public hearing. I believe, Brian, correct me if I'm wrong, but you guys do non-agenda item public comment before everything. Okay. So they would have to speak at the next public comment. So the next meeting if they wanted to, but that's within your right. That's how the agenda is set up. So that would not be a problem. Public hearings, as you know, are required for certain things. So they're required for any change to a zoning ordinance. They're required for site plan approvals, special land uses, rezonings, all those things. That's why you guys don't have an agenda public comment, because almost everything that comes before you has a public hearing. So that's why you guys do it that way. The purpose of public hearing, as you all know, is to listen and take into account the opinions of the residents, so the people that are going to be affected by these things. That is why it's so, so important to wait until after public hearing to make your deliberations. Because if you opine on something before the public hearing, again, that appears that you've already made a decision and that you genuinely are not considering what is happening at public hearing. Go ahead, next, Brian. Do you guys have questions about public hearings, public comment, any of that before I move on?
If somebody's making a comment during public hearing and you don't understand what they're saying, would you ask them at that time to explain it in more detail, or would you wait till the end and ask them? I mean,
Wait
truly,
till
if they
the
say
end of
something,
public
you don't know what
hearing?
they're talking about. Pardon?
Wait till the end of public hearing, or wait till the end of their statements?
Either, just what's the appropriate way to handle it?
You can absolutely ask for clarification on something that is being mentioned during public hearing, or when someone is speaking during public hearing.
Okay.
Yep, absolutely.
But I do, just as a rule though, it would always be better, I think, for a member to direct that through the chair.
Always, yes. Very good point, Dick. Thank you.
Could you repeat that?
It
Yeah.
would-
Go ahead, Dick.
Okay, like I say, it's always better for you as a member to direct that question through the chair and let the chair handle the person at the podium.
the item.
Otherwise, it sometimes ends up in a back and forth between a member of the commission and somebody at the podium.
Yeah, what you would do is you would say, Mr. Chair, I have a point of order.
Yeah.
And then direct your question to the chair. The chair will direct the question to the resident.
Yeah.
Generally, it's always better to go through the chair for anything. And we'll talk about this in a minute. In fact, I think it's on this slide. You don't want to go back and forth with anyone. You don't want to go back and forth with a resident. You don't want to go back and forth with a consultant. You don't want to go back and forth with another member of the planning commission. It gives the appearance of disorder on the commission, and that's never a good thing. So my recommendation is always wait till the person is finished. Direct your questions through the chair. If you have multiple questions, you can direct them through the chair. Question 1, question 2, question 3, and then cede your time to the chair, who will then allow the other person to respond. That's the best way to do it. Does anyone have questions about that before I go on? Yeah.
So how would I say that, Mr. Chairman? I have a question for the resident.
Yep.
And then I would ask
Yep.
the chairman my question.
And then Bill would ask, the chair would ask the resident.
Okay.
If I think I know the answer, am I
You're the chair.
free
You're
to say
controlling the
that
meeting.
too? Okay,
Mhm.
not that I have all the answers.
No, you pretty much do.
I'm sure that you do, Bill, with all your experience.
All right, are you guys ready for me to move on? I know it's getting.
But from a practical matter, usually what happens is, Tom, you'll ask a question, Mr. Chair, I have a question. I need some clarification on what the speaker said. I don't understand blank. And usually what the chair will do is turn to the speaker and say, could you please clarify? You don't need to necessarily repeat what Tom said, because the person
Everyone
already
hears
heard
it,
it.
yeah.
So, yeah. But it's just,
Mhm.
it's just good practice to direct everything through the chair, because you could see things sometimes could degenerate between an irate citizen or
Yeah.
somebody and the commission.
And you don't want
No.
the person at the podium and somebody in the audience bantering either, and so
Mhm.
you keep that,
Right.
yeah.
And there was a good example of that, of the chair handling and calling a meeting to order at our last meeting, when the resident was standing here speaking about his rental property, and he kept directing his comments to a member of the audience, and you did a great job of calling the meeting to order and requiring that the person at the podium direct their comments to the commission. So that's a good example of that, for sure. All right, we're getting there, guys. So the next, you guys know this. In order to pass a motion, anyone can make a motion at any time, as long as a motion's not already on the floor, as long as you guys aren't deliberating on something else. In order to make a motion, someone states the motion, I move to XYZ. Another person then seconds it. Once that happens, everyone on the commission has the opportunity to debate. In order to keep things moving, we'll talk about this in a second, but it's always best for each person to get an opportunity to speak one time who wants to speak before someone gets to speak again twice. That's the smartest way to do it. It just makes things fair and equal. So that's my preference. Then once deliberation is finished, then the chair will restate the motion. Then everyone will take a vote. We'll do roll call. And then once that's done, the chair will announce the vote. Motion passes, motion fails, whatever. If, once the motion is made, someone wants to amend the motion, there's two ways to do this. The person who originally made the motion can move to amend that motion. The motion to amend then needs a second. Once the motion to amend has a motion and a second, then everyone will vote on whether or not to amend the original motion. If that motion passes, then you vote on the motion as amended. If that motion fails, then you vote on the original motion. Alternatively, anyone can make a motion to amend as well. That needs a motion and a second. It's just easiest when the person who makes the motion amends it, then we know it's gonna pass. Or we have a pretty good idea it's gonna pass, I should say. Does anyone have questions about that process?
I do.
Yes.
So if somebody makes a motion
Mhm.
and they want, and I want them, or somebody wants them to say, can you include planner's comment number 2 in that motion, or subject to planner's comment number 2?
Mhm.
Do I have to wait until it's seconded and then go through the amendment process, or can I do that at the time the motion is put on the floor?
So you're saying, Belinda, I'm so sorry, I can barely read without my glasses. Belinda makes a motion, and you, before a second happens, say, actually, I would like this to include this. Then Belinda could amend to the motion,
Okay.
say, with whatever, and then a second would happen, and then it would be voting on the original motion as opposed to a motion to amend. Does that make sense? Usually what I do when,
In our practice
That's-
is we always ask the person, will you include the addition of the safety path? You forgot that in your motion, I believe. And the person who made it says, yes, I'll accept that amendment. to the
and if it
motion."
happens after there's already a second, which sometimes happens, people move really quickly, then all that would need to happen is the person that seconded it would have to agree to amend that motion.
Both the person who made it and the person who seconded it. Okay.
Mm-hmm, exactly.
Okay, that's what I thought, but, yeah.
You know, a common thing that I see with commissions is when you get, you are a deliberative body and you're here to make a decision, if you're ready, okay? But then I find discussion continuing to move on, and you're deliberating. Sometimes the best way to come to a conclusion is for someone to make a motion.
Yeah.
And that then starts to focus on the action.
One more question kind of related to that. The person making the motion can refuse all amendments to it and say, I'd like a vote on my motion as is. Does the second still stand? Yes. Then up or down, you vote, right?
Yep.
You don't
Yep.
have to accept amendments.
No, you don't have to. No. And as a general rule, it's always better to phrase your motions in the positive. So I vote to adopt X or approve X, even if you intend to say no, right? Because if you move to deny and then that fails, then the question is, what really just happened? We're in a limbo, right? If you move to deny and then the denial fails, then you didn't approve it, you didn't deny it, you did nothing with it. So always better to just have a motion in the positive. I move to adopt, I move to approve, even if you do not want to do so. If you're hesitating, if you really feel you do not want to adopt something, but obviously you don't know that you have the votes to say no, and so you just don't want to make the motion, I recommend you don't make the motion. If no one makes a motion, then you can move to table it, because it seems like you guys don't have a consensus on what's going on. That would be my recommendation.
But how do you ever get to the point, if it's just a flat-out denial, how do you, at some point, you gotta get to that point?
Well, then, if you're pretty positive it's going to get denied, you would move to approve it, and then everyone would deny it. Or, I mean, if you're 100% confident it's going to get voted down, you can move to deny it. But there's a danger there that I'm trying to warn you about, right? If you move to deny something, and then that doesn't get the votes, the motion fails, then you have this application that's just sitting out there.
Yeah, you have to do something at that point.
If you move to approve and it doesn't get approved, do you then have to move?
Then it's denied.
No,
It
then it's
is denied then?
Yeah.
Yeah.
That's implied?
Yep.
You could approve it with other conditions.
My thought on that would be something that would be determined based on deliberations. So if everyone appears to be inclined to grant something with conditions, that should be pretty apparent from the deliberations. and then that would be a time to amend the motion. I think you guys generally have a pretty good idea of what's gonna happen by the time deliberations are ongoing.
Yeah.
Do you have a question?
Yeah, I don't wanna be, like, well, ZBA, for example,
Yep.
we don't always, but if it's appropriate to deny, we demotion to deny. So you're saying
You
we should close
can.
it in the pot, that means one person has to throw out basically a,
You can. I just want you to be aware of the potential consequences. I would say only move to deny if you're confident that it should be denied and it will get, you have the votes to
I
get it
think in the
denied.
past, when we didn't get the votes, we would then follow it up with a motion to deny, or an amended
Or-
motion that did pass.
A different motion.
Yes.
You can do that.
I guess I have a problem personally making a motion on something I'm gonna vote, motion to approve on something I'm gonna vote no on.
I get it.
I,
I wouldn't make the motion then.
Then everybody just sits here.
then it's,
That's true.
and then you move to table.
Then you move to table it. You can poll on the commission, not outside of the commission, but while you're in an open meeting, if you're not sure, you can poll your fellow commissioners as chair. If you're concerned that you don't have the votes for something, or you're not sure where people stand, you can poll before you do a vote.
One of the more usual things that I see happening is when you have, like tonight, you have an even number of members on the
Yeah.
board.
Oh, God, yeah.
And, you know, a motion for approval is a tie vote. Well, in essence, then did not get the majority vote, and so that's a denial.
Mm-hmm.
But conversely, that's where it becomes confusing, though. If you do have a motion to deny and it comes up on you don't get a majority vote on that, that's where it gets really confusing,
It's tough.
yeah.
Yeah.
Do we have to ask the chairman to make a motion? I know we have.
You don't have to.
Is it proper etiquette to?
Anyone who wants to can make a motion. In fact, most of my commissions and boards don't allow the chair to make a motion. Anyone else is allowed to make a motion. You guys don't have that rule in your bylaws, so you are allowed to make motions, but most times the chair will propose a motion and then someone else will move based on that language and then another person will second, in my experience. But the chair is allowed to make a motion, anyone else is allowed to make a motion. If you feel more comfortable, you can ask the chair to make a motion.
What's behind that?
The reason for it is because the chair is supposed to be controlling the meeting. So the chair is in control and has the most authority on the board, right? You don't want to appear to give that person too much authority by allowing them to control the meeting and say when people speak, say when people don't speak, and then also allow them to make a motion, because that could give the appearance as though that person has some sort of influence over other people if they state their opinion on the record by saying, I move to XYZ. It's not true. You guys are all adults. You guys all have your own opinions. You know what you're doing. You're all experienced. But to a lay person, it can appear as though that person is exerting control over the other commissioners. That's why they do
I
it.
was gonna say, I've been a chair before in prior life, and I was always reluctant to make motions because as a chair, you're the most verbal person. And I just didn't wanna feel like I was controlling.
It's that appearance of impropriety thing. You're not doing anything wrong, but
Yeah, our previous ZBA chair never made a motion, he refused to. He's just like, I'm the one who's
neutral.
telling people what to do during the meeting, I don't wanna act like I'm running the whole show.
Exactly. That's exactly it. Yeah. But you guys don't have that rule, so you are allowed to, if you feel so compelled. All right, I think we're ready for the next slide, Brian. It gets simpler from here. So obviously we've discussed the importance of motions. Motions are how the board speaks, so those are what are included in the meeting minutes. If you guys violate Robert's rules by one of your motions, if you don't follow the proper procedure and a motion is adopted, you're not gonna get overturned in court for that. It's not that big of a deal. The court will look through the meeting minutes and potentially any recordings of the meeting to determine the intent. And then we'll rule based on that intent. Any discussions that happen either prior to or after a motion is made are not included in the meeting minutes. They are also not considered if it goes before the court. Only the motion itself is considered. And that's what's specifically included in the meeting minutes. All right, next.
Question?
Yes?
You mentioned possible to have the motion repeated.
Mm-hmm.
Is that usually something that's the secretary to do?
You can do either. Usually we have the chair do it.
Okay.
Yeah. And that's another reason that we don't.
I'm just a lousy note taker.
Sometimes for my other planning commissions, I'll repeat it, just because I'm paying attention. So really you can designate that obligation to anyone, whoever you feel comfortable.
Okay.
All right, now we're going to talk about the Open Meetings Act. You all know this, but the point of the act is to make sure that nothing's going on behind closed doors, no one's doing anything that they shouldn't be doing, and as a result, every decision that is made by a board of a governmental body in the state of Michigan has to occur in an open meeting. Go ahead, Brian. The question is, what is a decision? And what does it mean to deliberate? So, the Open Meetings Act specifically states that a public body must meet in a public meeting, an open meeting, if there's a quorum present, and if that public body is meeting to deliberate towards or render a decision on something that affects public policy or that they're going, basically any act they're going to put into law. So the board has to vote on any sort of ordinance in a public meeting. Any decisions that you guys make, that must occur during a public meeting. The question is, what is a decision? A decision is defined in the Open Meetings Act as a determination, action, vote, or disposition upon a motion, proposal, recommendation, resolution, order, ordinance, bill, or measure on which a vote by members of public body is required and by which a public body effectuates or formulates public policy. What that means is that if you guys are going to discuss any application that is before you, you have to do it in an open meeting, unless there's a reason that you can do it in closed session, which we'll talk about in a second. If all 6 of you wanted to go out to dinner and chat about your lives and have a good time, you're allowed to do it. As long as you're not talking about any of the applications that are in front of this body or may soon be in front of this body, you're fine. Really the biggest thing is if it's in an application that's going to come before the Planning Commission, you shouldn't talk about it with multiple members of this group outside of a meeting. And the reason for that is that we don't want the residents to think that there is some sort of reason for your decision that you don't feel comfortable sharing in an open meeting. Does anyone have questions about that? Mm-hmm.
What about something in the past? Can you talk about something that was already in the past?
If you're not going to render a decision on it, so if you're not going to make any sort of determination as to it in the future, then you can talk about that. That's not a problem. Any other questions?
So, I think you just answered my question, but I just want to make sure everybody's clear. If you're in a setting and wherever it is, and you're going to discuss something that eventually has to be voted on, it won't be voted on during that meeting, but eventually, you can't do it. That's right?
If there's a quorum, so a quorum is a majority of
Yeah.
this body. So if there are 4 of you present in a location and you want to talk about something that you know is imminently going to come to the planning commission, do not do that. Any other questions? All right, next, Brian.
Are you staying on that topic?
We're still
Expanding
talking
it?
about Open Meetings Act, yep.
Okay.
So the next thing that we're going to discuss is ex parte contact. It's pretty similar to the previous slide, but the difference with an ex parte contact is it's not communication between a quorum of the planning commission. It's communication between a member of the planning commission and an applicant or someone else who has special knowledge about a project that's coming before the planning commission. Avoid any sort of ex parte contact if at all possible. The Michigan State statute, no, this is just the Open Meetings Act. I thought we were going to define ex parte contact, but I can define it for you. Ex parte contact, like I said, is just any contact that occurs between a planning commission member and an applicant or someone associated with the applicant. Really, the reason that you want to avoid ex parte contact is you don't want the appearance of impropriety. You don't want to be voting on something that you learned outside of an open meeting that the entire body, the township, the rest of the planning commission is not aware of. My recommendation, because sometimes ex parte contacts are inevitable, they happen without your consent, say someone, an applicant, emails the entire planning commission, and then you now have a communication from them, or emails a couple members of the planning commission, not the whole thing, something like that. If that were to happen, if there's ex parte contact, and you're going to base your decision on anything that you learned in that ex parte contact, my recommendation is always to mention it in deliberations so that then the entire body is aware of it. That way, you're not basing your decision on something that you only secretly know. It's information that you disclose where you got it from, and everyone else can then consider. Do you have any questions about that?
Is that how pre-planning meetings get around that?
Well, pre-planning meetings are with the administration.
Well, but they have planning commission members in attendance at those.
Not, you
Not
know,
in a quorum.
not a
setting.
quorum, though.
No, not a quorum.
As long as everything that happens at that pre-planning meeting is disclosed in the planning commission, which it is, then you're fine.
And generally, the applicant goes into it knowing that everything is non-binding discussion at this point.
Okay, but I get that, but you said it's not a quorum. But if I'm understanding this ex parte communication, it's any one of us. It's not a quorum. If I have a conversation with a developer about his project.
Technically, that's true, but it's different than the Open Meetings Act quorum issue because that's a clear violation of the Open Meetings Act. Ex parte contact is not a clear violation of the Open Meetings Act. It's just frowned upon. So if you have a discussion with the applicant, as long as the entire board is made aware of it, it's in the public packet, the public is made aware of it, then it's not a problem because everyone is aware of it. It's not secret knowledge, if that makes sense.
You know, interestingly, the Planning Enabling Act does permit the chair to have subcommittee meetings. And technically, that's why we asked the chair to appoint the members of a subcommittee on a particular, for a pre-application meeting, because it is permitted by law. I think the difference is, it's still part of a public process, because our ordinance in some instances specifically requires a pre-application meeting. So I think that's kind of the distinction. I think what we're talking about is the developer wants to contact individual planning commission members, and that maybe even does. And that's all behind the scenes. I mean, you know, so here, it's official part of our process. So I think that's what makes the distinction.
A lot of times too, our pre-application meeting, you know, that subcommittee, what was discussed at those ends up coming out as part of the discussion, you know, for those specific members.
In fact, a lot of times it'll be in my reviews about, you know, about what was in the pre-application meeting.
That's exactly right. That's the
Yeah.
main difference.
Yeah.
And again, I'm going to reiterate. The reason that we discourage ex parte contact is because it looks bad. This does not look bad, right? This is it's sanctioned by the zoning ordinance. It's in fact required, and that information is then provided to the entire planning commission, and it's also then dispersed to the township and their township residents. That's the difference. Really, the reason that the stereotypical ex parte contact is prohibited is because it gives the appearance that if, say, some developer comes to you, Bill, and says, I want you to do X, Y, Z in the next planning commission meeting, it makes it look like you have some sort of conflict of interest. That's the reason it's typically frowned upon, and that's why you can get around any sort of typical contacts and a contact between you and a developer by disclosing it at the planning commission meeting. It's making sure that every single person has the same information as do the residents. That's the way to resolve it, if that makes sense. Do you have any more questions about that? Okay, all right, we're ready for closed session. So, as I said, the only way that this planning commission can deliberate outside of the public eye is in a closed session. There are 8 ways you can get into closed session. The first is if there is some sort of discipline matter with an employee and they ask to go into closed hearing, if there is a collective bargaining agreement negotiation, if there is going to be a purchase or lease of real property, to consult with an attorney regarding trial or settlement strategy, in connection with specific pending litigation, to consider the contents of an employment application, and finally, and this is really the one that you guys would use to go into closed session, is to discuss a written legal opinion or memorandum with the township attorney, or to consider other material that's exempt from discussion or disclosure by state and federal statute. The other ones really don't apply to you. They apply to councils and boards outside of the planning commission. Next slide, Mary. In order to go into closed session, you have to already be a part of an open meeting. And then someone needs to move to go into closed session. That needs to be seconded and then approved with a 2/3 roll call vote. Both the roll call vote and the purpose to go into closed session can be as general as to discuss a confidential legal opinion with the township attorney. Those need to be recorded into the meeting minutes. Then everyone will go into closed session. All of those discussions are confidential. You can talk about anything in the legal opinion, but you cannot make any decisions during a closed session. If you guys want to make any sort of vote on a matter that was discussed in closed session, you need to move to end the closed session and then go back into open session, where you then need to move to do whatever you want to do and take a vote on that. When you are coming out of closed session, that motion to end the closed session and the time at which closed session ended need to be in the minutes, as do, this is not on there, but the time that you go into closed session also needs to be in the minutes. Do you guys have any questions on closed session?
Does that ever happen? I mean,
I have a closed session for a planning commission next week, but it's rare. It's very, very rare.
We had one a few years ago. We had
Yeah.
with Deer Lake.
You're like,
Just a question on that. Typically, it's a legal matter, so the motion coming out, it can be ambiguous. It doesn't have to get into detail, or we could go, I motion that we approve the agreement that our township attorney advised us to enter into. I mean, you wouldn't really mention the parameters of it in a motion,
No.
I wouldn't think, because
It
it's,
depends on what it is.
yeah, obviously.
But yeah, and almost always, or at least this is what I do with any of my closed sessions, if I want my board, or if we agree on a motion that we're gonna make, I write the motion out
Yeah,
before we get back into open session, so that you know exactly what you're gonna say.
gotcha.
Yeah.
Morgan, I think where we've had that circumstances in cases in this township where there was an existing consent judgment on a piece of property, and the action of a planning commission on a particular development proposal was gonna be materially affected by that consent judgment, it was very important for the planning commission to understand what their constraints were or their limitations
The
might be.
legal ramifications.
And that's happened, I think, a few times here in the township,
Yep, that's exactly
where
right.
we've had to go into closed session so that the commission had a clear understanding of what the consent judgment said and what they could and could not do in the action that was gonna come before them.
Mhm.
Did we do that, Brian? Did we go into closed session on the Deer Hill property?
I thought we did.
I think we
Yeah,
did,
I think we did.
And the Belcher ticket item, I think it was twice, if I
Yeah.
remember right.
The docs.
The
Yeah.
dock, yes,
Yeah.
the dock situation, yeah.
Yeah,
Both where there was pending litigation. And a lot of
That's
times,
typical.
I mean, a lot of times, something will get sent back by the courts and have to come back before the planning commission.
Yeah, if you have to amend a consent judgment, which does happen sometimes, in order to get a site plan approved, then that would be a reason to go into closed session.
Yeah.
Mhm. All right, are we ready to move on? Next, Brian. So the next thing that we're gonna talk about is any use of electronic communication during a meeting. That includes email, text, Snapchat, I guess. Anything, any sort of email or electronic communication that occurs during a public meeting is part of that public meeting. That's considered a deliberation. As far as the Open Meetings Act, there's case law to support that. And as a result, if that occurs, especially, I mean, primarily between members, that can result in an Open Meetings Act violation. So we highly discourage it. If you need another reason to avoid emailing or texting during a meeting, all of that stuff is then FOIA-able. So if someone, a disgruntled resident, a disgruntled applicant, sees you texting during a meeting, even if you're not texting someone that's on the the commission, you're texting your husband, that then could be FOIA-able, and then you have to give the township your cell phone, your email, and they have to look through those items and then provide them to the person requesting those. You don't want to do that. So highly recommend that you avoid that, even if it's on your personal device. Does anyone have questions about that? All right.
Morgan?
Yeah.
Can you discuss doing that outside of a meeting? Like,
Yeah.
you know, people posting on Facebook or something like that.
Feasibly, anything that you do that involves township business is FOIA-able. Actually, we have this in one of our other communities where one of the writers for their little neighborhood newspaper really, really hates one of the council members, and so every single time, like after a council meeting, he will FOIA her cell phone, her email, and she has to provide it. So,
Can't imagine.
and if you can feasibly refuse to provide it, of course, but then that person that's applying for the FOIA can go to the court and require a court order to get that information. So if you are using any sort of electronic communication that has anything to do with the township, that is FOIA-able, even if it's outside the public meeting, even if it's outside normal township business hours, even if it's on your personal device. All of those things are FOIA-able because you are appointed officials for the township and you're discussing township business. Technically, it's township matter. Go ahead.
Question. So it was my understanding, like, I'm not emailing anybody on the planning commission, but if I had a question of the trustees, I could address the supervisor and blind carbon copy all the other trustees, and that's okay.
You can do that. It's FOIA-able though. But yes, you can do that. That's not a problem at all.
Tell me what that means. I don't really.
Sorry. I should have explained this better. FOIA means Freedom of Information Act. That is a law that allows any single individual person to file what's called a FOIA request with any municipality, any division of the government, and request documents. And if it's if it's anything related to the township at all whatsoever, the township has to provide it. Go ahead.
Well, one other question, because I'm on the planning committee, but I'm still a resident. I have opinions and a brain.
Mhm.
So if I have a question, is it better that I come to the trustees and stand there where you're at to ask the question, or should I send it to the supervisor and copy in the trustees?
You're saying on something that's outside the scope of your role as a planning commission
Yes.
member.
Yes.
My recommendation would be for you to follow the formal process, for you to appear in front of the board during public comment. Alternatively, you can submit a letter to the board for public comment. If you are speaking as a resident alone and you have a concern that you want to bring to the supervisor's attention, you're legally allowed to send it to the supervisor and all the trustees, blind carbon copy all of them. My recommendation would be to, instead of copy all the trustees, you could just send it to the supervisor.
Okay, because I thought it was supposed to be blind carbon copied to all the trustees, so that everybody, not just one person, but everybody.
It doesn't have to be. The reason that you're BCCing people is so that it's not obvious who all you're sending it to, so they don't have every single other email.
I thought it was just so they couldn't hit reply all, and then it is an open meeting, so.
True. I mean, that's helpful, but yeah.
But just to clarify, if this was a rezoning, if we were hearing a rezoning, it would be a violation of open meetings for her to email trustees, blind copy them, and discuss that rezoning, because that rezoning is ultimately gonna go to them too.
To discuss it, yes. It's technically not a violation of the Open Meetings Act for her to send her opinion. Is it inappropriate? Yes. And to explain why it's not technically a violation of the Open Meetings Act is because she is a member of the Planning Commission. She's not a member of the board, so her sending a request or information to the board is not a deliberation as a part of a quorum, because the quorum is for the board and not for the planning commission. If one of those trustees then responded and there was discussion, then that would, yes, be a violation of the Open Meetings Act. However, again, the planning commission member should speak during an open meeting and through their open meetings. So any point that you want to make should happen during an open meeting.
Well, when you come up to the podium where you're at now, I mean, do I have to identify myself that I'm on the planning commission, or am I just Belinda Billings at 6025 Cedar Bend?
It depends. It depends as if you're speaking as a planning commission member, then you identify yourself as a member of the planning commission.
But if I'm just
If you're just speaking as a resident, then you don't have to identify yourself as a planning commission member. Nope. Any other questions? Because this is actually the end of our presentation. Thank God.
Just to wrap up the electronic communications, I'm not on Facebook, but some people like going on Facebook to Independence Township comment sites,
Mhm.
and they'll post stuff about development going on. So that's totally inappropriate for a board member or a planning commission member, I would assume. You know, like, oh, this is horrendous, we shouldn't have done this, I'm gonna go get them, kind of thing.
I really don't want to discuss specific situations because I'm not aware of all the facts. That being said, individuals are allowed to act as individuals as long as it's clear that they're not representing the township. If they're not holding themselves out as a representative of the township, then you're allowed to post your own opinion on a social media forum.
Gotcha.
I don't know about this specific situation, obviously, but
It's
That's
not
general
addressing a
rule of thumb.
specific
okay,
one
good.
per se. I mean, yeah, obviously, there's been several over the last years and years, but nothing specific, really.
Gotcha. Does Does anyone have any other questions about anything?
I don't know that I'd ever do this, but if I wanted to, on the site and where people post a lot of stuff about planning commission, if I wanted to say, subject X is on the agenda for Tuesday night, is that a problem?
Mm-mm.
Okay. And could you elaborate a little bit more about planning commission members emailing amongst themselves as well as applicants?
My recommendation is that the planning commission members should not discuss anything that is before the planning commission in email before a meeting. So, because that constitutes deliberating towards. Even if there's not a quorum of members, it still appears as though you are violating the Open Meetings Act, even if there's not a quorum, so I would recommend not doing that.
Even if one of the commission members wanted to email me and ask for my interpretation of an ordinance as it applies to a particular application.
You can ask questions. So
Can I answer them?
Yes, so the prohibition is discussing opinions, so deliberating towards a decision. For example, it would be a violation of the Open Meetings Act for someone on the planning commission to email 3 other planning commission members and say, this is my opinion on this subject, do you agree with me? Or even, Bill, if you called Brian the day before the meeting and said, hey, I think Belinda and Tom are voting with me on this, what do you think? That's a violation of the Open Meetings Act. If you have a question about how an ordinance applies to an application, and you can ask that and someone else can answer it. That being said, my recommendation is to direct those questions to our consultants and Brian, because they're the experts here. So if anyone's going to have the answer to that question, it would be one of them. And then it reduces, again, that appearance of impropriety, because you're not talking to other planning commission members about something that's before you. You're asking the experts about what they already know about.
It's also potentially discoverable in the case of litigation.
Yeah.
Okay.
So you
Very
would
true.
then be putting yourself out there to have to produce your email, your text message, maybe your phone records, the whole 9 yards. It can get really messy.
Yep, I agree.
Man, I feel like Big Brother is watching.
And
Dick, do you generally take field questions, or is it your firm that takes questions, or how? Is that common or uncommon?
Yep. I mean,
We've had, recent discussions in the last couple meetings that are just, the topics require a lot of thought. Some things seem to be more clear-cut, and other things, there's a lot of maybe legislation or
yeah.
how,
Well,
how do we just address, hey, this is what I'm thinking, do I ask you a question, should it go to
the
Brian?
best,
or-
yeah, the best
Yeah.
policy is to address it to Brian,
Okay,
and frequently Brian will forward it to me for a response.
okay.
That way, he can keep control of his budget.
Well, that's it. but-
Exactly,
but it's-
right.
But it's
No.
also something that may be of universal interest to the entire commission.
Very good
So then
point.
if I communicate back to Brian, it's perfectly fine for him to send it out to the commission as information.
Okay.
So that's always the best way to do that. Now, from a practical standpoint, Brian and I very frequently work directly with the chair on agenda items and things like that, and will continue to do so. But that typically is the only member of the planning commission that we will have that kind of direct communication. I mean, I can't say that I've never gotten a call from the planning commission, because I do, and I typically, I'll answer it. But it's always best probably to go through Brian, because he might be able to answer the question and avoid me, or, not that he tries to avoid me, but avoid me having to do it. Or if he feels more comfortable, he'll have me answer the question.
Sure, Great.
Yeah. And, the same thing will happen with the engineer too. You'll have an engineering question or a question about drainage, for example, and it might have to go to Jason. So Brian is always kind of the gatekeeper.
A couple more questions, I'm sorry. A couple of weeks ago, I read an article, it was very interesting, about Airbnbs and how they're affecting communities. I was tempted to forward it to all the other planning commission members. Wasn't my opinion, it was just interesting. That would be okay, right?
My recommendation would be to send it to Brian, and then Brian can disseminate it.
Okay.
It's always better to go through Brian, and then he will disseminate everything, because that avoids the appearance of impropriety.
Yeah. See, then it's going through a public channel, basically.
Yep.
Whereas if you do it privately, it is always, there's, this suspicion that you're doing something behind the public's back. That's why it's always better to go through the public public venue.
So what, this, kind of the spirit of what I'm asking is, we all have an interest in all these topics, right? So it would sort of make sense that we could collaborate together, and, so far as I can see, that the only time we can collaborate is for 1 or 2 hours once a month on Thursday, and it's like, some of these topics you wanna dig into and really spend time in. And so that's kind of the spirit of what I was getting at. Like, hey, if you find some great article that might be very informative, how do I get that? We could spend an hour each finding the exact same article, or one person could spend an hour and send it to Brian, right? And then the rest of us could read it.
I mean, we're always available to provide you with information. For example, though, but this happened, that doesn't sound right, but you know what I mean. At a planning commission meeting where the discussion of woodlands came up, and your chair asked me to provide examples of woodland ordinances, which I did.
Yeah.
That's an example where, where you can use our resources to provide you with information. Let's say that you're interested in hearing about accessory dwelling units for a matter, like, I'm just using that as an obscure topic. Again, we can always provide that, but Brian is sort of the conduit for that information, and will ask me or whoever he sees fit to get that information to the planning commission.
Yeah, promise, Brian, I'm not gonna deluge you.
It's always okay to email me questions or
Yeah,
call.
Yeah.
I mean,
Yeah.
And there's nothing wrong with that. Or if you don't understand an application, something that you got in your packet. So,
I'm under the impression it is at least taboo for board members to try to express their opinion on planning issues to planning commission members. Can you comment on that?
That could appear to be a form of ex parte contact. Any appearance that someone is trying to influence a decision appears to be ex parte contact. And if that influences your decision, then you can disclose that during a planning commission meeting and explain the basis for your decision. You don't have to disclose it if it doesn't influence your opinion, but if it is compelling, then I would disclose it.
It's particularly problematic if it's a matter that's going to ultimately come before the township board too. I mean, particularly problematic. If you had board members that would regularly attend your meetings and sit in the back of the meeting, and monitor what you're doing, or, as you say, directly try to influence a decision that you're making prior to them making the decision, it really is, it's very problematic.
I agree.
Do you have to leave? Do I need
Yeah,
to formally
I was gonna
excuse
say,
you?
point of order, Mr. Chair, I'm late.
Okay.
All right.
Go,
Your
go
excuse.
get,
Thanks, guys.
is it your son or your daughter?
Daughter.
Okay,
Have a good night.
Thanks.
see you. Take it easy.
See you next time.
What was oh, I think I know the answer, because I think you addressed it, but
Next week.
like during the course of a deliberation on an application, it becomes clear that there's a lot of open items, and we're not going to approve it that night. And I did this on Mel's Diner.
Mhm.
And I didn't want to lead the guy down the path to put a lot of adjustments in his site plan and spend another month and come back and get denied. So I kind of said, you know, what do you think here, guys? Are we, you know, is there enough here? I want to give the applicant a flavor.
Yep.
Is that okay?
Yeah, as long as it happens during an open meeting, absolutely. That's not a problem.
Yeah,
Okay.
that was very effective. I mean, sometimes what happens is the planning commission will postpone a matter, and we don't have any real direction what to tell the applicant what they need to do. And so it's always better if you are able to enumerate what you are. And the other part about it is sometimes if we don't have a consensus, we may have one opinion from one person, but that doesn't reflect the entire position of the commission. So what you did was really helpful, Bill.
Okay.
And the more that you can do that, the better. Especially, we have a formal way to do it when you have a site plan between conceptual and final, but in that case, you were being asked to make a final decision. So before you did, it was helpful for us to know what was on your mind.
Anybody else got questions for me?
Well, I kind of do, but it's on the master plan. Is that okay to ask a question here about the master plan?
The
Not yet.
document itself or procedure?
The document itself.
We're gonna
Be here for a couple more hours.
we're gonna move on that next.
I thought we were leaving.
We're not gonna ask Morgan to stay around
Okay.
for that, so that's, we
Oh,
can,
I wanted to talk to Morgan. So how can I talk to you?
I'll give you
before-
my card.
Okay.
Yep.
thank you.
okay.
Does anyone have questions for me?
Thank you for
All
coming.
right.
Thanks.
Of course,
Thank
it was a
you.
pleasure to see you guys again, especially so soon.
Thank you. Thanks, Morgan.
Thank you,
Great
guys.
job.
Okay. Next item, master plan update.
Thank you, Morgan. Appreciate it.
Let me just start by saying, I want to lay out what the procedure is moving forward. And what you have before you is a draft document. It is a draft based on some input from the planning commission. That was not most of you. It was based on some public input. It's obviously heavily based on the existing master plan to a great extent, and updated, based on a joint workshop between the planning commission and the township board. So there's a variety of things, but the one thing it is not based on at this point is your opinion. You are now the sitting planning commission, and you are, most of you, with the exception of Tom and Brian and Ron, were not involved in this as we moved along. So you have, you need to feel comfortable with this document, because what will happen at some point is when we completely go through this document and it's at the point where you feel comfortable, what you're going to do is you're going to have to send it to the township board, and they are the ones that act on its release for the public comment period, okay? And you can have public comment even prior to that point if you wish. You can have a public workshop, you can have a public meeting about it. But the formal adoption process starts when you send this document to the township board. And the law requires that the township board allow its release for public comment. That starts a 63-day, don't ask me why it's 63 days, comment period in which this document is sent to all the surrounding communities, any public utilities or railroads that are on file with the clerk's office, and Oakland County Coordinating Committee. Once those comments are complete, those comments all come back to you, and at that point, you have a public hearing, or you modify the document and then have a public hearing on it. But it is required that we have this very open, coordinated review process. That was all part of 2008 Act amendments called the Coordinated Planning Provisions, so that this plan is coordinated, neighboring communities are given the opportunity to review any particular boundary issues or any kind of issues that are of concern to them. Yeah, Joe?
If the public comment is initiated by the board, not by the planning commission, we skip that part, okay? Then the comments come back, but they come back to the planning commission?
Yeah,
not
they'll
the
still
board?
come back to the planning commission. It's just the law requires that the board has to release the document.
Okay.
The other decision that the board, the township board has to make is to whether they want to be the final adopting body of this document. Traditionally, in this township, we have always taken the plan to the township board and asked for their either endorsement or adoption, even before the act required it. And the reason we did that is because we want this to be a policy document that both boards live by and provide guidance for decisions. And if you think about it, it makes sense, because ultimately rezoning decisions come before the township board, and the board needs to rely as much upon the master plan as you do as the planning commission. So that's why we've always felt it's necessary, and we went outside what the act required and asked the board to adopt it, and they have. I don't see that there'll be any reason why they would deviate from that. They adopted the last plan. But it will be a plan that comes from you, then at that case, as recommended for adoption by the township board. So that's where your role is. So,
Question,
yeah,
clarification. The public hearing, is that run by the planning commission or the board?
yes, public hearing, planning commission.
Okay.
Yeah,
And the board doesn't have their own public hearing?
they can if they want to. Yeah, and they usually, since they'll have two readings of a resolution of adoption, or two reading. Well, actually, it's a resolution, so they would.
It's just a resolution.
Yeah, it's just a resolution, so they wouldn't have two readings, but frequently the board has taken public comment on it too, so. Prior to you sending it to the board for their release, you are by all means welcome to have as much public comment as you wish to have about it. You are able to have it reviewed by whoever you want to have it reviewed. For example, you want to ask the Open Space Committee to review the open space provisions, by all means do it. You want to ask the Public Works Department or the Safety Path Committee to review the infrastructure section, by all means, you can and should do that if that's what you want to do. So, but to get to that point, you have to get to the point where you're comfortable with the document, you obviously have to go through this document and tell me what you think needs to be addressed. As I told you at the last meeting, a lot of it is revision of what was in the current master plan. The one major differences in the master plan in 2015 and 16, the Planning Commission at that time decided that they did not want, they felt that they did not need or want as aggressive in a public participation, so we didn't do it. We did it. We allowed public comment, we allowed review of it, but I advised the Township Board and the Planning Commission when we started this process a couple of years ago that because we hadn't had a tremendous amount of public input over the years that was more formalized, that we needed to do that with this plan. And so you'll see in the appendix a report of, and it was actually, pretty extensive, and it was why it became more time-consuming and somewhat more expensive to do, because public participation is costly. So we did a number of activities where we got input from a whole variety of different groups and everything. We had a survey, which the results are summarized online, where we had over 450 responses. I thought was really, I mean, not bad. I mean, you know, we would have liked to have 44,500, but, you know, to get 450 people that were from, what was impressive is the way Brian laid it out. It was arrayed from all over the township. And what was equally impressive was the respondents in terms of their longevity of residence. It was split like 50-50 between, I think, people that had been here 10 years or less and people that had been here, you know, for much longer than that. So it was a good combination of people who have lived here a long time and people who were newer residents. So I think that is also very revealing and very telling. So the question I have for you now is, how would you like to go through this document? And I know you've had some time to review it. I don't know if you have specific comments or questions. If we do, we should go through it in sort of a sequential manner. It would make it a lot easier for me to follow along rather than flipping pages. But I think that would be the most, what I was sharing with the chair, what I hope we don't do is go through page by page. But when we go to a section, if you have comment or question, then we, you know, you bring it up at that point in time. So does that sound reasonable, Mr. Chair?
Sounds good to me. Everybody else okay with that? I mean, I assume probably everybody's read it, right?
Scanned it.
So,
Well,
yeah.
And I guess we can go as long, you know, you're gonna have to tell me how long you wanna go tonight. Because,
Well, if you see us nodding off,
Well, do you want us to just ask you about certain,
if that's easier for you,
rather than read the whole thing to you?
that's perfectly.
what about we do, you do a section, you announce the section.
Okay.
And then let's see if anybody has any questions on that particular section.
Okay.
And if you, based on those questions, if you feel you need to elaborate, you elaborate.
Why don't we do that then? So, we obviously have the preface is simply, you know, a summary that talks about the plan itself, the planning process. And one of the things that we've added in here, because people always get confused about it, is the difference between the master plan and the zoning ordinance. I'll kind of lump these two together because the preface and the introduction are pretty much the same. The introduction talks about all the previous plans that have been done. And you're now a planning commissioner in a township that it has a long, rich history of producing and maintaining a master plan, long before I was here. Actually, the first evidence of some type of master plan was in the 40s. 1966 was the first formal document that Brian and I were able to find. I started here in 81, and I think 84 was the first plan that I went through. So you have a pretty rich history here of public, of boards and planning commissions that took planning very seriously. And by and large, these plans have been kept up to date and have been followed, you know, has provided a lot of guidance. So that gives a little bit more background about that history. So before I go on to any of the background information, is there anything about any of this that you have questions about? Okay. As part of every master plan, there's certain basic background information that is provided. What we provide you here is in a summarized form. At the outset of this planning process, we produced a more detailed community profile that has more detailed information. Is that on?
I don't think it's on the website, but it will be.
Okay.
Yeah.
That will be on the website, but basically.
When?
Well, I'm gonna do it in different format, so it's gonna be a little bit different. So, sometime this year before it's adopted.
Well, it's gotta be done, I mean, it should be done.
Yeah, but I'm gonna do some kind of dashboard. for it.
Okay. There are printed copies of that report that can be sent to you.
Yeah,
Do you have it in a digital form?
Yes.
I can PDF.
Yeah, we have,
send
have it in a digital format. So what you have here is a summary of that data that's in that, in that more complete study of background information. And, you know, in that is, it's, you know, inventory of physical, environmental resources, it's demographics, it's existing land use, it's an inventory of community facilities, it's a complete discussion and inventory of what's here right now. That's what's included in the community profile. One of the reasons why we do that, particularly when it comes to demographic and housing information, is every 10 years we have a census in this country. And so that includes more up-to-date demographic information that's either based upon the published census data, or a lot of the information we get is from SEMCOG, which is the Southeastern Michigan Council of Governments, that has very up-to-date community profile information on their website. By the way, if you ever want to find out stuff about any community, go on SEMCOG website and look up community profiles, and you'll get very, very detailed demographic information. So in this, we outline sort of what the context of planning is in the township: population growth, what your infrastructure is, housing, existing land use, community facilities, what your transportation network is, and probably one of the more important things is existing land use, where we updated the existing land use inventory and the existing land use map. So, are there any questions or comments about that section?
Just so you know, the community profile, I just looked at it, it's too big to email, so I'm gonna send you a link to it. And we also did a market analysis, which I think is very interesting also.
Yeah, like retail market analysis. Okay, well, I'm gonna keep moving on until you stop me. The next section is the goals and objectives. And these are a set of goals and objectives, you know, if best described perhaps as aspirations, visions, and the way this is presented, and many of these are a continuation of goals and objectives that have evolved since 1997, when we did the Vision 2020 strategic plan for the township. And you might say, wow, that was 26 years ago, and we're still, well, it turns out that that was such an extensive process, and so involved such a large number of community members, that the things that were identified in that strategic plan have really carried forward over many, many years, and we've continued to refine and revise those, have eliminated some because they were no longer relevant, and obviously added to that from that standpoint. The Planning Commission has liked this format where the vision is expressed, that sort of establishes the aspirations of the community that we hear, you hear from residents and from public participation that goes on, that's then interpreted to specific goals and specific objectives. So that's really how this document flows and how it's evolved over the last 20, 25 years. You'll see a similar format of presentations, but one of the things I encourage commissioners to do is that a plan is not a map. A plan is the whole document. And where you're searching for guidance about what the direction that a community should go and can go, you go into these statements for these goals and objectives, and it gives you a lot of background in terms of what you as a planning commission have decided is the direction you want to go. And a lot of times, you're going to see these in my reports. You'll see something about commercial land use, for example, and it's very specifically citing a particular objective that's part of the master plan. So that is where you rely on the narrative and the words that give you the proper direction. You're gonna see through here that, for example, you're not gonna see any aspirations to have a regional mall in Independence Township. That, for example, is, very highly reflected in our commercial goals that we, and so if a regional mall is being proposed in Independence Township, you're gonna realize that for a long period of time, that has not been something that has been desired in Independence Township. I'm using that as sort of an extreme example. But we lay this out by residential land use, commercial, industrial, office service, recreation and conservation land use, public and semi-public, and essentially those are the goals and objectives. So these were reviewed by the Planning Commission about a year ago, and they were revised to reflect the comments that were received. That's not to say that you won't have further comments. So are there any comments about these? So far, so good here. All right. Something that we found when we did the strategic plan, it was a lot. I mean, we could reflect our land use plan in a single, as a single document, as a land use plan, and make it very generalized. And that's how most master plans are done. However, we felt in this community that we had some specific geographic areas of this township that deserved special attention. So we broke the township up into 5 or 6, and we've consolidated some since then, into what we called target plans. For years, this entire area, starting actually before I started with this, the township had aspirations for the Sashabar Road corridor when it was nothing but fields out here. And so there was always special planning that had been done for the Sashabar Road corridor. We came on board, we took it a few steps further, but every time, it became more and more refined. And it wasn't until the strategic plan in Vision 2020 that the concept of a town center really emerged. And that's how the plan emerged for this particular area of the Sashabar corridor. It's not, one of the things that our commission emphasized is that, we were, as a township, we weren't going to be able to do something that was more or less contrived as a town center. We weren't going to try to replicate the city of the village of Clarkston, because we have that. We have this gem right here within our community. But we wanted to have an area that was comprehensively planned, allowed for mixed-use development, and remarkably had infrastructure planned in advance of development occurring. And for the most part, that has been the case. Obviously, there's been some areas that have been done differently than others, but the idea has pretty much been consistently followed. The same thing with Dixie Highway. Totally different situation, obviously. I mean, in a completely different type of the need and the inability to plan from the ground up, because it was already existing, presents all kinds of different challenges. And so we felt, a specific target plan for the Dixie Highway was important. The same thing with White Lake Road. White Lake Road essentially being the only area where it's not so much this way now, but the only area which was predominantly the area planned for industrial. And it's only been in the last 15 years or so that commercial has been introduced to the White Lake Road. But we still have some industrial land use there that's, challenging, an asphalt plant, a waste disposal site, a bunch of different stuff there that for a long time is going to probably still be there. But a lot of the area has been remarkably cleaned up from what it used to be. The northwest part of the township is, an area of the township that could have gone completely different directions had the township let it go that way. M15, north of the village, that entire frontage north of I-75 was all zone commercial. Township went through a very aggressive process of downzoning that property to office service, and it's made all the difference in the world. And a lot of that was driven by the desire to prevent the spread of strip commercial development all up and down M15. And if you notice, that hasn't happened. The second part of it was to preserve a substantial area of the township that has a rural character that literally has not changed for 40 or 50 years from the standpoint of the character, the rural roads, the large properties, the areas where there's horse farms. There's not a lot of farming that goes on anymore. Distinctly separated from the northeast area, which has a mix of a rural character mixed with some other types of older traditional development that was part of the old lakefront development on Walters Lake and Thindara. And so we had whole different challenges there. But by and large, the character of that area has remained substantially the same. So this is why we did these target plans, to be able to reflect the unique difference between these areas and reflected in our planning. And I think it's been an effective tool because we're able to articulate more specific design objectives and things like that you don't see in a normal land use plan. So that's the concept behind what's in the target plans and why we went that approach a number of years ago and have just sort of carried it forward. Now, all of these have been updated to reflect more current circumstances. And it's true. I mean, things like Dixie Highway, many of the things in there are highly aspirational. But, 5 years ago, 10 years ago, our DDA wasn't active. And now we have an active DDA that can help affect some of these changes. So that's the background between the difference with the master land use plan and the target plans. I will say that the land use plan from 2015 to now there's no changes on it between that and now. So with all of that, I'll be happy to answer any questions about any of this. Yeah, Tom?
I had a question on, we've talked about it before. On page 53, it talks about the Dixie Highway overlay, and I know you guys have mentioned that before. I was just wondering, is that a group that meets once in a while, or?
No.
You
mean the overlay?
With the movie Clarkston Theater, the redevelopment of that, I think we mentioned the overlay district, and I just wondered if.
Well, there's a Dixie overlay district. That's a zoning district.
Okay.
Yeah, the overlay district, the concept for the overlay district came out of earlier master plans in order to have specifically, more prescriptive design requirements, first for the Sashabaw Road corridor. That's where that first occurred. And then later on, the Planning Commission decided that they wanted to have a mechanism to, over long term, to try to improve the visual appearance of Dixie Highway. And that's when the Dixie overlay provisions came into place. And again, all based upon concepts that came out of the master plan. But no, that's not a group. But you did have a corridor improvement authority, but, they've pretty much done their job. But I think that, the Downtown Development Authority will rely heavily on what's in the master plan too, because I think they're attuned to that.
Can you talk about how they operate, what they do,
Yeah, good-
what can they do?
Good question.
Yeah, that's a great question. Let's start with the Corridor Improvement Authority, because it's the same. Mixing law allows you to establish corridor improvement authorities and downtown development authorities. In the mid-'80s, the township was expecting Dixie Highway to be improved, several large development projects that were on target to occur. The township had to have a mechanism to improve infrastructure on Dixie Highway. And at that time, the only tool that was available to us was to establish Dixie Highway as a downtown development authority. Now, you're used to, Joe, probably a downtown development authority in a compact urban environment, but the law did permit townships to establish those, because in essence, at that time, Dixie Highway was our equivalent of a downtown, at least from a standpoint of commercial base, okay? So the Downtown Development Authority existed for 10 years, because by agreement with the school district, because at that time, we used tax increment finance dollars. That means that we were able to capture a percentage of the increase in taxable value that resulted from the improvements that were made. So as long as that money was spent in the district, we were able to capture tax dollars from the township, from the county, from the community college, from HCMA, and at that time, from the school district. Because at that time, the school district was, quote, in formula, and every dollar that we took got reimbursed by the state. So we literally invested tens of millions of dollars in Dixie Highway in infrastructure, in street lighting. That's how the street lighting got installed. There was some safety pass built. There was water. There was sewer extended. And all that was in advance of the highway being, well, it wasn't in advance, but it was in conjunction with the highway being widened by MDOT, and the construction of two shopping centers, where White Lake Commons is and where the Kroger's is, and Lancaster Lakes Apartments, that generated a lot of tax base. That dollars were all spent back into Dixie Highway. Yes, Joe?
So you mentioned like the DDA or the overlay district being, tools for
Mhm.
improvement. So this is what you're talking about.
I am, yes.
Okay, yeah.
And the DDA then extended down White Lake Road and was responsible for the relocation of White Lake Road. It used to come off at an angle onto Andersonville Road, where you see it now directly aligning with Nelsey Road. That was a DDA project. The DDA also extended water and sewer down there that allowed the commercial development that you see now to be developed. So the DDA ended in 1995. Well, what didn't happen is the township board never formally dissolved it.
Yeah, right.
So in 2018, the township was informed by the state that we still had a DDA on the books. And meeting with, I think first with Mr. Kittle, And then later with Jerry Fisher, the township supervisor, the decision was made, let's resurrect the DDA. Because legally, we could. Because it was established, the other taxing jurisdictions could not opt out. Now, the school district was no longer subject to capture. So that's what we did 2 years ago, and we now have an active, functioning DDA that this year will begin to start capturing tax increment finance dollars to be able to improve the Dixie Highway corridor. So this year's capture will only be about 120,000, but it goes up from there to eventually the point they'll be capturing several $100,000 a year that can be put into beautification, identification, signage, wayfinding, infrastructure. We want to improve the safety pass system. So that's,
Now, how do those improvements do they get coordinated at all with the planning commission, with the board, or the DDA final authority, or how does that work? When you get the $100,000, who's gonna spend it?
yeah, well, part of it is, the DDA is gonna spend it, but it is coordinated with the township board because the township board has superintending control over the DDA. The township board approves the budget and basically has to, the DDA has to work in conjunction with the township board because probably at some point in time, the DDA might have to come to the board to ask for an advance of money to do certain projects. Plus, if we apply for any grants, the township board will have to approve that. So that is all coordinated with the township board.
And one last, how does the zoning ordinances apply? Can the DDA override them?
No,
Okay.
no,
so
that's completely the
still-
planning commission's responsibility.
Okay.
Now, the same thing happened with the CIA. We created the CIA strictly for infrastructure. And that's what has provided the money to be able to do, the boulevard portion was done strictly with township funds, but because that predated the CIA being established. But everything else that you see in terms of road improvements was all done with the CIA and actually leveraging, using TIF dollars to leverage, millions of other dollars to be able to afford these improvements. Bill, you brought up the issue of the Sashabaw-Walden intersection, I think, at one meeting. The CIA had really much more aggressive plans to correct that entire situation, but for the fact that we were unsuccessful in working, in convincing MDOT to put enough money into the bridge over I-75. So all the improvements that you see there were basically paid for through the Corridor Improvement Authority and other matching money that we got. But what, the biggest constraint right there is not the intersection, it's the bridge. And that's really what happened. We originally had programmed $28 million in the CIA budget to essentially replace the bridge, but did not. But what did happen that has created a tremendous amount of relief is the off-ramp going to southbound Sashabaw, because prior to that existing, the only way to get off was from northbound was backed up, all on 75 when Pine Knob was. So that's been a major improvement that the CIA did. So those are the two major mechanisms, but the CIA is basically going to sunset. The last project is going to be a signal up here, Walden Center and Walden. And then the CIA has completed all their projects and are just basically paying back money to the township board that was bonded. But the DDA is just beginning to start. So back to your original question, collaboration between the Planning Commission and the DDA would be really essential to turning that into a better circumstance than it is right now, Joe.
How does that happen?
You can just request it, I mean, you got
I think having joint working sessions between the two of them, I mean, getting goals aligned, you know, asking the DDA should weigh in on this plan, and that's really the beginning steps right there, because the DDA may come back to us and say, you know, to effect certain improvements here, you know, we really need to see certain, you know, we really would like the planning commission to address certain changes in the ordinance, for example. That's actually how the overlay district for the Dixie Highway happened. It was not a DDA, but it was a committee that we had set up. Sam was on it, and I can't remember a number of other people. And that's really how the overlay district came into play also, because we wanted a mechanism to take some of these old obsolete properties and give them an incentive to redevelop. So that's really, that collaboration is really essential. Yeah, go ahead.
Do you provide like the same kind of services to the DDA that you do to the PC, or I don't understand your
Yeah.
relationship with the DDA?
Yeah, I provide staff support for DDA and CIA.
Okay, so could you be like a focal point in initiating communications between the DDA and the PC?
Yeah.
I mean, would that be a good idea?
Yeah, well, absolutely. What Dick said is critical. I mean, we need, if you want the DDA to weigh in on the actual plan, I mean, we had focus groups with the DDA and the CIA.
Yeah.
We did a joint focus group with them, but now that it's in print form, absolutely.
Yeah.
It seems
We,
like,
we did that. One of our focus groups was with the two groups, because we thought the DDA would benefit from the CIA's knowledge about what they've done over the last 10 years, so.
yeah, so there's been a couple of properties, there's probably several more, right, that we'll be reviewing right there in the Dixie, on the Dixie corridor area. And it only makes sense to have the DDA, especially with like landscaping features and this stuff, it seems like it's necessary to coordinate with them if we don't wanna come up with our own kind of concepts and then move one way and then it ends up going in a different direction where the DDA has an overall vision. We're looking at one property at a time, right? And they're looking at the whole picture, so
Mhm.
the design concepts, or maybe there's continuity or whatever, that makes total sense.
Right. Yeah, and, you know, there's several different elements to that you're right about that. For example, you know, we have a very disjointed safety pass system right now along Dixie Highway. That's one of the things that are part of the DDA plan. And by the way, the goals of the DDA are incorporated in this plan. So in essence, if you're adopting this plan, when you adopt this plan, you'll be adopting the goals as part of that too. But some of that infrastructure coordination and all that is really, and the only reason it hasn't happened so far is because the DDA it's just gotten organized, you know, and really, until they started capturing money, which is this year, there really wasn't anything for them
Yeah.
to do.
What, so, staying there for a second, what other communities have a successful model of like the planning commission and like a DDA, or are there multiple DDAs for some communities?
You're only permitted to have a single DDA in any community, but you're permitted to have multiple corridor improvement authorities. So you can have more than one corridor improvement authority. So you might have, Independence is unique. We have a DDA and a corridor improvement authority. I just finished working with White Lake Township, and they're gonna have a corridor improvement authority down M59. You know, that's a really great question, and the thing is that traditional DDAs in communities like Berkeley, for example, or even Troy, I mean, they have such a different focus than what you would have. Like, in many of these smaller communities, like Berkeley, they may be a lot more involved in marketing activities. where most of your really critical needs here are really infrastructure improvement in many respects, you know? So for me to say, that would be hard for me to answer that question. But for you, I think it makes tremendous sense for there to be a lot of collaboration between the DDA and the Planning Commission, especially when, you know, projects are coming before you.
Yeah, I agree.
Does it make sense to have a formal liaison from the planning commission beyond the DDA?
Well, you're restricted, you could have you could have a non-voting member, okay? Because the laws, the composition is prescribed by law, and it has to be, the majority has to have a business ownership in the corridor. And then it has to have a citizen representative, and then you can have a couple of members at large, and then it's the township supervisor is appointed on both the Corridor Improvement Authority and on the DDA. But having liaisons would be a really, and, you know, they are going to start meeting every other month. So having a liaison attend the DDA meetings would be really beneficial.
It wouldn't have to be a voting member at all. It's
No.
just a matter of getting information back. and forth.
Exactly.
Are those open meetings?
Yes.
Okay,
Yeah, they are all official public bodies for which an open meeting.
so we could just show up if we
Yeah.
wanted and just kind of.
Brian, do you go to those?
Yeah.
How often do they meet? When you said they're gonna start.
What's that?
How often do they meet?
DDA?
Every other month.
It's, every other month, and that's their schedule, at least for this year.
Is there anybody here that'd be interested in serving that function?
I won't attend a few meetings just to get a flavor.
They're televised and on Teams, so
Oh,
And then,
you can jump on.
that's even
online.
better, right?
and then maybe consider being a liaison?
Possibly, yeah.
Okay. Brian, I'm gonna ask you to keep Jason posted on meetings, and then, maybe bring up the idea at a DDA meeting. Okay.
Yeah, I think that we could actually inform the DDA that the planning commission has expressed this interest in stronger collaboration. I think they'd be really pleased with that. And maybe we should put a statement here in the plan.
I think it's an implementation strategy, yes.
Yeah. Under the implementation strategies, there you go, see?
I like it.
I'm fascinated that somebody in Lansing or somewhere saw that this DDA had not expired and
Well,
alerted.
Yeah, that's the thing is, yeah, what happened, well,
Tax
it's because it was
dollars,
on, it's when they initiated the new statutory reporting requirements. When the law was changed in 2018 to require more specific reporting requirements from existing from DDAs, any form of tax increment finance authority. They saw that Independence Township had a DDA, and they were asking us where our annual report was.
Where's the money?
And the township called me and says, Dick, what's this all about? And I said, well, the DDA stopped operating in 1995. I don't, you know. And the more investigation we did, the more we found out that it had never been sunset, and it was still in existence. And somewhat to the dismay of the other taxing jurisdictions, we were allowed to resurrect it without their ability to opt out. So we did.
Okay, back to the master plan.
So anyway, that's the relationship between the master plan and the target plans. The target plans are simply a more focused representation of the land use plan, excuse me. So yes.
On the target plans, I'm specifically interested in the Sashbaugh corridor, because that's close to where I live, but I appreciate the boulevard landscaping and the high building standards and site designs and buffers and attractive visual aesthetics. And one thing I noticed, it says a natural stone and metal fencing, which looks really nice along Sashbaugh. And again, it kind of goes along with what we were talking about when we were talking about the short-term rentals. If you don't have someone enforcing maintenance, just like the Huntington Bank, which I gave Brian a bunch of pictures of, all their landscaping is dead. And they're also missing a couple of panels of their metal fencing. So somehow there needs to be enforcement of maintenance built in. And also, under commercial uses, again, it's talking about something that's near and dear to me. It's talking about retention ponds. And I did look over under infrastructure and stormwater management systems. It talks about MS4 system and LID, low impact development. So I went to that, the manual for Michigan that you were talking about, that this is based on. And in here, it talks about planning commissioners have numerous opportunities to encourage implementation of LID in their community. First, the planning commission typically updates and adopts the community's master plan. Incorporating LID into the master plan would be an important step in implementing LID in the community. The planning commission also reviews new development proposals and proposes language for zoning ordinances. The commission can ensure that zoning and development ordinances allow the use of LID techniques, write LID requirements into ordinances as appropriate for their community, and encourage development of LID concept. Because in this LID program, it talks about maintenance of retention ponds. And I don't think we even cover any of that in our zoning, and it needs to be included. And I know you say you can't go against HOAs, but if it's somehow could possibly affect homeowners in flooding and stormwater management systems, it seems like we should have some kind of teeth in our program or in our documents that does talk about that.
Just as an aside, not to get too deep into the weeds here, but like in my HOA, because I'm involved with the retention issue, our HOA agreements, when it was first, signed by the county and the township and all that, says the township will, if the HOA doesn't, the township will enforce
So does
and
mine.
go after, the retention, and then bill back, I don't know what the process is, and I'm sure it's lengthy and crappy and everything else, but then bill back to the HOA. So at least in some pre-HOA agreements, or whatever you call them, covenants, part of the deeds, I don't know what, there is teeth in there to give the township control over the HOA on retention issues. It's there.
There really should be something in our plan that gives people that live in HOAs some kind of hope beyond their board that's not doing anything. The township, the only choice I have is to go to the Attorney General, because there used to be a board that oversaw HOA boards at the state level. But now, when you call any of those numbers, they say you have to go to the Attorney General or hire an attorney. Well, it seems like our township should somehow be involved in that to protect stormwater management systems or wetlands. I mean, I'm attached to a wetland, so, and those drains go feed to the wetlands. It seems like our township should be involved in all of that.
I'm not as familiar with your specific situation, and so I'm taking this in. I'm not really sure what the response is. Joe is correct. There are some master deed and bylaw provisions that do give the township some enforcement responsibility. I haven't.
Mine say the same thing.
I haven't been, it's been so long since that development was built that I don't know what's in there specifically, but that's certainly something, yeah, that we can look into.
What, have you ever run across this in other communities? Retention pond maintenance and long-term
Well,
provisions for,
You know, as a matter of fact, the community that I live in, but we're also the consultants to require that stormwater management facilities be actually established as a county drain district, so that there is a mechanism for maintenance.
Well, John Jones with Eagle, at the state level, told me that new developments are being required by their townships to have a maintenance schedule, which is awesome. But what about old developments, because my pond is 30 years old.
It's actually the county that's requiring that, so it's not the township.
Well, even if it is the county, I live in Oakland County, so it seems like some of that should flow down to Independence Township. I mean, there should be some kind of mechanism to protect homeowners living in HOAs. And
Well-
this LID, I mean, you're talking about it right here, MS4 and LID, it actually has a maintenance schedule in here, so I just think it should be maybe more developed.
Would that be something, because we're talking about the master plan, which is like a forward-thinking document, right? This is our goals, but I think what you're talking about is like a zoning, right? Would that be a zoning
Well,
issue, or?
it's not, I mean, it's not really a zoning issue, it's really, well, it is an HOA responsibility. In some cases, there is a fallback to the township, but in many cases, there is not. Let me say this, all of this really came about when condominiums were determined by an AG opinion that were single-family site condominiums were considered to be a legal form of land development. They never used to exist before. And it's really because the Subdivision Control Act made subdivisions so impossible. Under the Subdivision Control Act, there was mechanisms where storm drainage facilities were a public mechanism. And so this is what's created to some degree this problem, in that in a condominium, the homeowners are responsible for all of these elements, because none of them are public. They're all private facilities. And I guess we'd have to look into this a little bit further in terms of seeing, what the end effect is, because if it's simply just affecting those homeowners, it really is that homeowner association's problem to solve. But if it's creating a problem off-site, then that's a whole different issue.
Well, it could be both, because in our little subdivision, we only have 48 homes.
Yeah.
And I agree, it's our HOA's responsibility to dredge that pond, but the only ones that care about it are the ones that back up to the pond. The rest of them think, out of sight, out of mind, but that is the storm water. That pond is retaining the storm water and keeping other homes all around it from flooding, not even the ones that back up to it, because if the drains stop up, 2 streets over, where's the water gonna go, in a big storm? So,
But-
plus it drains into the wetlands.
but historically, when we require retention ponds, we leave that up to the property owner to maintain those forever.
We have no mechanism to do it.
Know what?
No mechanism to do
Yeah.
it.
That's what I'm saying, we need a mechanism.
Well,
I'm saying, as a township, there are mechanisms, and, I think that's something we could explore. You can have those come under the jurisdiction of the drain commissioner's office as a drainage district,
Well, even if they
if they're
stay,
willing to accept it.
even if they stay under the jurisdiction of the HOA, there should be someone at the township that should do an inspection every 10 to 20 years, whatever, and issue something to that HOA board and say, it's probably time you get your pond dredged or whatever. Blow out that line that goes to the wetlands. There needs to be, because in my subdivision, they're talking about spending $15,000 on a play structure and ignoring the pond that has never been dredged. So those are the things that frustrate me. There should be some mechanism that the township can have some teeth and say to those HOAs, you need to get this done.
Well, let me ask you, is this a master plan issue?
Yeah,
or-
I
mean,
don't know.
You know, I mean, you're raising a legitimate question. I
Well,
mean,
it talks
we're-
about stormwater management in here and LIDs. I'm just saying,
I understand, but I mean, we're still talking about, I mean, so I'm thinking that this is it's a question, you know, that needs to have more, you know, exploration, you know,
Yeah.
internally here, because I don't have an answer for you.
okay.
I mean, I know in other circumstances how it's done, but that's because the drain commissioner's office has a legally established mechanism where they can take jurisdiction of the storm drainage system.
Well, and the
We
road
don't, this township doesn't have that, I don't think they have that legal jurisdiction, but do they have the enforcement capability, or the enforcement authority and capability? That's something that we're gonna have to
No,
explore.
but the issue may be, and we'll never resolve it here,
No,
but do they have it? I don't know. Should they have it is the issue,
Yeah.
not do they have it.
exactly,
Yeah.
exactly.
And it's something, like Brian said, needs to be explored further, and it's not to be included in this version.
Yeah.
Because it's too late, but at a development, I'm eating my fudge here. It's good fudge, right?
I didn't want you to lose another tooth here, Joe.
Yeah, right.
It
But
does
I'm-
affect the infrastructure of our town, like the road that
Yeah.
they had to come in and repair because of erosion, so.
okay.
Well, you raise an interesting point. I mean, I'm not aware of this, and I'm not sure it's part of the master plan, but it's certainly something that we can have further discussion about.
Yeah, it should go on the to-do list.
Okay.
Yeah. Not for resolution tonight either, that's for sure.
You looking for more comments, or do
Yeah.
you wanna, okay, anybody else have any questions or comments on the master plan?
There's a page 95, I think, 94, just a real point of clarification, what does it mean, a sub-district? Like, for example, the sewer and water sub-district?
There were two special, so I'll provide more explanation in the plan, but there were two special sub-districts established for water and sewer service that are contained only to those areas. And particularly critical is the one in the northeast part of the township at,
Heather Lake,
yeah,
near there?
Heather Lake. Only Heather Lake properties can be serviced by that. We've had in the past developers that have wanted to tap into that system, but there's not the capacity. It was established strictly for that purpose. And the same thing with the Deerwood subdivision. You don't know how many times we have gotten pressure to extend sewers from the Deerwood subdivision north into the northwest part of the township for servicing. And the township has successfully combated that. So I will put more explanation in the plan about that, because I think it's significant.
Thanks.
Anybody else? I was wondering, you know, I think since 2015, there's been in my mind, I am no expert on this, a downward demand for commercial and office space. And I'm wondering if it doesn't make sense to kind of reduce some of that area that we've got master plan. We've got some vacancies, both along Sashabaw and along Dixie. And to the extent that we master plan more land available to be used in those classifications, we are discouraging reuse of those vacancies.
So
And,
like down zoning, you mean, or?
well, down planning, because if it's zoned, yes, if it's just master planned,
Oh, I see.
change the master
Got
plan. And I think by doing that, we could encourage, I don't know if I'm using the term right, but more in development, within stuff that's already pretty much fully built out but not being fully utilized. And I'm thinking Sashabaw, north of I-75 on the west side. There is some parcels in there. Not big, as we've pointed out, but a number of them. I'm very familiar with Sashabaw, obviously. I'm not that familiar with M15. Maybe that's a section 2. Dixie, there's not much, it's, yeah. So I'm wondering if we should think about that.
I mean, you certainly, you can. One of the reasons why the area on the west side was designated mostly for office service was to try to discourage residential, primarily because of Pine Knob. And circumstances may have changed since then. I mean, better sound control and everything like that. But it was also to prevent it from becoming all commercial too, across from Pine Knob. So I think it's a great idea, but I think you're gonna have to think about what you want it to be as an alternative, That will be the challenge.
So you don't think it would be a desirable location because of the proximity to Pine Knob?
Well, in the past, we've had a lot of issues with noise and traffic from Pine Knob. And where a lot of the complaints came from were further west on the west side of Sashabaw, because
Like
that's where.
Wingate or that area?
Yeah,
Wingate.
Wingate, yeah. And I think, that, we, as an alternative to commercial along that busy road frontage, that's why we designated most of that area for office service, to avoid more residences there to complain about the noise, or two, having, commercial development all the way up that side of Sashabaw. So, I mean, I think, the alternative probably would be some form of housing, but in a higher density, perhaps not for more of a for-rent type project. That's why, the elderly housing projects seem to be perfectly fine, because it's more of an institutional type of building.
They probably can't hear.
Well, I mean, it's better sound insulated and
Yeah.
all of that.
Yeah, you can't hear a peep out of that when you're
That type of construction is, there's more sound insulation, and they built it to be able to withstand any type of issue in that regard. So think about it. I mean, that's certainly, there's certainly a possibility there, but you're gonna have to think about what you want it to be.
Just as I travel around Metro Detroit, and there's all these perceptions that if it's on a busy road, it's gotta be commercial or office, but yet,
No, you see a lot of residential too.
look at Woodward Avenue, Bluefield Hills,
Yeah,
$1 million homes
yeah.
on a 8-lane or whatever it is highway. I mean, so it makes me question that stereotype that you can't do it. I forget, what is, when you look at various types of land use, what is the highest generation of traffic? Commercial, industrial, office?
It's always, even within each general category, there's always producers of higher volumes of traffic,
Sure.
but, probably generally commercial. But, you know, traffic by category, there's different peaks for traffic too. And that's why that's a little difficult to complete.
Understood.
But you know, you probably have to say that most commercial types of, you know, like a fast food restaurant, for example, for the size of the property, probably generates much more traffic than an office building on that same size of property, for example.
I'm not suggesting we become Manhattan, okay? But I mean, if you're living in a very high dense population residential district like Manhattan, where everything goes up instead of this way, you know, there are no cars, people don't own cars, you know, they walk to here, they walk to there, and everything they need is within walking
Right.
distance. And if it's not, it's a cab or Uber or something like that. This population, what I read, and these are not studies, these are more opinion, anecdotal things that you find in the newspaper, is getting older. You know, Independence Township is getting older.
Correct.
What kind of discussions are there about adopting or adapting to the older population? And I don't say that as an expert, but before getting involved with you know, with the township here, I was on a whole bunch of senior commissions with the state. You know, and it's all about where are the seniors going? You know, the move is to not put them into monarchs. The move is to keep seniors in their homes for as long as you can. That's where all the money is going in Lansing. Daycare facilities, daycare workers. I forgot what the term is, but to stay in your home, not move to a nursing home. Are any of these discussions, you know, serious in the plans here? And, you know, I'm not looking for a very specific thing, and, you know, didn't you cover this with these 18 families? I'm not talking about that, I'm just talking the general theme of where we're going, and are we gonna have to adapt to a population whose average age is 65 instead of 45? And
Yeah.
if that's true, how are we gonna do that? And these people don't need big homes, they need smaller homes. I'm in a home twice the size of what I need, at least, or what I can keep up. Could be really both.
It does talk about, following the design of complete streets, right? I think that's part of it, moving around
Well,
outside of, you know, automobiles, moving around town. I mean,
yeah, well,
that seems like one way.
to answer Joe's question specifically, yes, the plan does speak about the fact that the township's population is aging. In fact, under the background studies, it says, let me see here, yeah. So population continues to mature, the availability of housing targeted to empty nesters will be an important component of a strategy to maintain an important element of our community.
But we have to implement some strategy, you know.
Correct.
And not tomorrow, but you know what I'm saying, this is all long-term, I'm talking about long-term thinking. You know.
And the goals also talk about housing is to be provided for people of all ages of life. One of the things that we did do in this version is to separately population, housing for an age-related population was always lumped in with our multiple family category. We've broken that out. Now it's a separate category, so that you at least know what it is that you have, and senior housing is a separate land use category in the plan. So it is recognized that we have it, and we need to accommodate it, and you're gonna need to accommodate it even more.
Right, aging in place, that was the term.
Aging in place,
Right.
or as the term, Joe, I talked to you about, aging in places.
Yeah.
We have areas here where we could build housing for people that can't or don't want to age in their house. They want to age in a small community. Bill, something we talked about earlier is something that I see very realistically happening here, where you have housing for empty nesters, but it's really more developed in a cluster type of arrangement because I see that as, is still a need in the township. But by and large, most of the projects that we've had in the last 10 years, I mean, quite a few of them have been targeted towards an older population, because that's where the demographics are.
One of the last things that we did, and I don't know if it's got a place up here or not, of course, this was in the woods, so it was,
Yeah.
you know, constrained. But we built the rivers, and the rivers was the building, which was a nursing home. A separate building was assisted living, a separate building was independent living, and then we had independent, single-family, or whatever you call them, condos, you know, detached condos, all in one property, all within 2 blocks of Mack Avenue. You know, so I mean, it just worked out that way. It was a nice experiment, but it was small, because, you know, we didn't have any land in the woods to speak of. Actually, if you know where it was the Detroit, it's where they put juvenile delinquents. And it was the Detroit home, they tore it all down, it was on Cook Road.
And now this is where older delinquents live, right?
Yeah, right. But anyways, it was a good experiment where they had all these different kinds
Yeah.
of services, residential services for an aging community. You almost move from building to building to building,
Yeah.
you know, as you age. And the good part of it was somebody was thinking about how to adjust, whether that was the best solution or not, I don't know. It's filled, and they're paying taxes, so I guess it works okay. But people were thinking about it, and they moved on it, and they did it. And I think that's where we're going. I mean, we're headed, we should be headed anyways. And I think, you know, your comments are well taken in there. You know, they're identified, now we have to do something, I suppose,
Yeah.
I don't know.
Yeah, actually, since the previous master plan, there have been 4 new projects comprising 56 acres that focus either on senior housing or convalescent care. So, I think that part of the market out here now is pretty, I don't want to say it's saturated, but it's pretty well satisfied for the time being. But what really is not is housing for the more active seniors, who are not, the average age of people in assisted living is 85 years of age. And, you know, the empty nester process begins well before that, as I well know.
My community is pretty much retired people.
Right?
Yeah, it's very nice.
Yeah.
I don't think it was built with that in mind, not specifically with that in mind, but.
Children's Home of Detroit, that's what that
Yeah,
facility was. It was
exactly.
torn down.
Right. Well,
Yeah, one of the things, you and I talked about this, that I would like to see is, I'll refer to the implementation section. I read through this and I read a lot of the goals and objectives, and I'll use the Dixie Highway corridor. It talks about pedestrian-friendly architectural design, or similar designs. It talks about access. And when I read through our ordinances, I don't see specific enough ordinances in there. I mean, for cross-access, in my mind, I think we should have almost a requirement that adjoining parcels have a cross-access to each other. And if the neighboring one isn't developed or conducive to development right now, I recognize you can't require a neighbor to change his property because this piece over here is being developed. But you can require this piece, parcel A, to develop his site with a stub to his neighbors and the appropriate cross-access agreement between the 2 parcels. So when parcel B gets developed, you can make him comply, and eventually you'll get there. this has to do with the car wash. I drove up and down Dixie, and there's very few cross-access. And I don't wanna focus on cross-access. This is an example of what I'm getting to.
Yeah.
If we want to accomplish that in the Dixie corridor, I think we need an ordinance that puts that in place. If we want to accomplish, I mean, I watched the video on the car wash, and they talked about design standards. And the building they're gonna put up's a nice looking building, but it's, I would call it very modern or contemporary. And, you know, some people said it doesn't really fit. It's a nice looking building. I mean, so if we want a particular design, we should say so. And those same kind of principles apply to all the goals and objectives. I would like to see an implementation plan that talks, at
Spells out
least
the
in
design
generalities, Dixie Highway corridor. Look at ordinances that can accomplish this, this, and this. Yeah, I'd like it to be a little more specific, because give us some goals for the next 5 years.
That's a good idea. I mean, as I was explaining to Bill, this section literally has not changed from the last master plan, primarily because it is, pardon me?
We haven't done any.
Well, we haven't had any development on Dixie Highway, first of all, but the fact of the matter is, this is where I want, you know, you need to tell me, and you are now, what you want to see put in this section, so, you know, this reflected what the last planning commission thought. This now needs to be done to reflect what you think, and so you know, it's a point well taken. And the fact that you want a work plan for the next 5 years is great. Too bad I'm not 5 years younger. It's almost like, it's like a, you know, it's like a consultant annuity is what it is.
Turn it over to your son.
They're aging in places.
But, yeah, no, I mean, I think we can be a lot more prescriptive about that.
Can you come up with some ideas?
Yeah, well, it's interesting because something I can do, I mean, now that I have the DDA plan in place, you know, I can meld a couple of these things together, because there are implementation projects involved in that are very much tie into this, so, yes, I definitely can take a shot at that.
Can I ask the 5 of us that are here, maybe put this on the topic for our next planning commission meeting, and all 5 of us review this with an idea of thinking of specific, but not, you know, what would be a good.
In the language, but points that
Yeah.
need to be included.
And we can discuss that at the next meeting, is that?
Yeah, you know, like, a perfect idea that came out of this, that could go in the implementation section, is regular liaison with the DDA, for example. So, it can be programs and policies, programs, and projects, more or less,
Man,
that come out of this, yeah.
I'd like, you know what I'd like? You know.
Well, I don't know yet, Bill.
Well, I mean, one of them is, specific ordinances to help accomplish
Yeah.
some of the, it's probably not just the Sashbaugh, or the Dixie Highway corridor,
Yeah.
it's probably, I'll probably come up with some other stuff, but.
I agree with that, yeah, I
Yeah.
think that's a good idea. I mean, we did a similar thing, it's not, but in the woods, we put in some ordinances for the streetscape, you know, it had to be colonial style, period, but that was in an ordinance, you know, that wasn't a wish list in the master plan, that was in the ordinances, not anymore, but,
Okay.
does that help?
It helps, but if you're gonna have a more specific discussion about it, if you're going to have a more I will hold off on doing anything about that chapter until is that what you're suggesting?
Well, that is an item to the agenda.
Yeah.
Yeah,
Yeah. And, yeah.
Okay.
I mean, I'd like to hear, I'd like you to be part of that discussion at
Oh,
the
oh,
next
yeah,
meeting.
absolutely.
Whenever you
Yeah,
come up with what you thought of.
yeah, exactly. But that's a good, I mean, I think it's a good, it's a good idea.
Teamwork.
So,
You know, and I said to Bill, when this is all said and done, this is your plan, not mine. And so it's got to reflect what you want to see.
Belongs to the residents.
You as the representatives.
yeah. So the next step would be to hear that, maybe you make some adjustments based on that,
Yep.
and then submit it in front of the group again, and we decide if we like it or want more changes, or,
Okay.
right?
Do we wanna, before we get too far, do we consider bringing in some of the DDA people to see what they're thinking, and, or is this too early for that?
I think,
Are they even
it's,
looking at that type of,
The DDA plan's on the website.
yeah, I think what the DDA is thinking is what's in the plan. So their thinking is, I mean, they've got their plan. I mean, what they're struggling with right now is what they're gonna do first, because they have a limited amount of money. The one thing they are, I think, gonna move forward on as soon as they can is doing some identification signage of the township, you know, entry signage at both ends of the corridor. I think that's something that's one of their first, that's at their last meeting at least, that's one of the things that they discussed.
Could I add,
Yeah.
ask a question? If that's such a good idea, and I think it is, okay, would we want to include that, Brian? I don't know if this is the appropriate question for you or not. The same entrance sign at other entrances to the community which are not part of the DDA?
The board's already working, well, the supervisor's working on it,
Okay, so that's,
totally separate from us here.
oh, okay, but I mean, it would be coordinated with the DDA, or at least the design standards or something. It's not gonna be,
We don't know, I mean, it's still in its infancy right now, and we can't say.
okay. But that would be horrible if the DDA would come up with entrance signs that look like this, and they would come up with other signs that look like that, and we'd have two different bill standards. No, never mind.
It could happen.
Well, that wouldn't be good.
No, I know.
Can you look at the commercial office zoning and see if there's any areas there that could reasonably be cut back?
Sure, certainly.
Excuse me, what does that mean, Bill? I guess I don't know your training.
Reduce the areas that are master planned for commercial and office, so that you maybe force a use of what's already available.
I got you, okay.
That's because,
Okay.
as I said, in my mind, there's been a reduction in demand for office and commercial space.
Well, that's true. I mean,
Yeah.
all you gotta do is look at that, what's that park and ride right there at the intersection of I-75?
Yeah,
That's empty. You know, in the middle of a workday, it's empty compared to what it was 5 years ago. You
yeah.
couldn't find a spot in there at 10 o'clock in the morning. Now you could drive several buses in there and a train and a barge if it doesn't hit a bridge.
Okay. That it? Ready to move on to the next item?
Well, I think that the Dixie Highway, it's a good idea. I wish I was a landscape architect, though. I don't have things to add as far as,
Yeah.
colors. And it seems like Waterford has some ordinance, because a lot of their shopping centers are painted the same color now along Dixie Highway. Have you noticed that?
No, I
Like
haven't.
on the east side? It seems like the,
Where?
like in Waterford, they're along Dixie Highway. It seems like a lot of the centers are color coordinated now, I thought.
That'd be shocking.
Okay. All right, next item, approval of minutes. We don't have any, so we'll do that next month. Table that to next month. I don't need to do it.
Oh, shoot.
It's just not on there.
You got anything else? Dave?
I think, was this sent out to the country previously? I brought it
Briefly,
to that.
Yeah.
Okay, I forgot. All right, you already have this. if anybody, I brought extra copies.
I've got it.
Yeah, just to make sure, but I'm sure I have it.
Yeah.
What is it?
It's
Yeah.
That comes
it's a
with
summary of the
Planning and enabling.
Planning and Enabling Act. And
Oh, yeah.
the one section in there that is really, one of the reasons I brought it, extra copies again, is there's a whole provision in there about the adoption, purpose and adoption of the master plan. So,
Okay.
You don't have a summary of the zoning enablement?
yeah, I'm working on it.
Okay.
That's one of my projects.
Next item is discussion. Brian, do you know what's gonna be on the agenda in April?
Yes, there's, two particular items. One is the, social medium, special land use for the community center that we had a meeting on. They did submit formally, and then, Mr. Carwash final site plan.
Okay,
And then we'll have implementation strategy after that, so.
I mentioned that because if anybody, the new people haven't looked at the car wash yet, so you have an opportunity to start looking at some of the past meetings. It's kind of involved, so. One, two, three, four, I guess we have enough to vote for adjournment.
Yeah,
I
if
second.
we wait much longer, we won't be able to adjourn.
Did the
Yeah.
Clarkston Theater
Yeah, I got 'em
redevelopment fall
before
through?
I don't, you can
I,
ask,
town,
yeah.
and I forgot to send it.
right, yeah.
That'll be a question for Carlisle.
Brian?
Yeah.
If we keep falling away one at a time and we don't have enough members to hold the motion to adjourn, do we have to keep?
You have to
meeting?
stay here.
Yeah, that's what I thought.
The Clarkson Theater, the question was asked, what's the status for that?
From my understanding, they walked away from that project. I've gotten a formal discussion from them, but
That's been sitting there vacant since I moved here 11 years ago.
no, it's been vacant a lot longer than that.
Wow.
It's hard to believe they don't do something there.
It's a code enforcement nightmare, about every 3 months.
Hmm.
They live in town, the owners. Actually, they claimed that the petitioner blamed us for them walking away, and it was gonna be too expensive. And stormwater management requirements, which is countywide standard. But that particular petitioner specializes in going into banks and reopening them, so wouldn't be surprised if they're gonna all go down here.
Did you find out who bought that or who's buying it? Oh, I heard today somebody told me it's the sheriff's department that's gonna move there. Have you heard that?
I can't talk about that.
Does it, you mean you can't talk about it, or you didn't hear about it? Neither one, huh?
Good enough.
Okay. Somebody make a
Motion to
motion.
adjourn,
At,
Okay.
I'm gonna say 8:22.
two.
I second.
All in favor, say aye.
Aye.
Opposed? We are adjourned.
Dick, we had enough for an adjournment.